Matter upgradation for pension matter.
No. No upgradation and no inclusion.
My lord, I am mentioning for withdrawal.
Withdrawal.
That is in the today item list.
Today's matter. What is item?
Item number 42 in the SSC.
47. Wait, it may be taken up. You can hand over the slip, I'll see.
My lord, may I be permitted to mention, my lord, the matter is pension matter which was mentioned before your lordship. It was allowed, requisition was sent to the department. Upon inquiry, it is found that the department couldn't trace out the file. They have informed me that I need to mention before your lordship so that order may be passed upon the concerned department so the file could be traced out, or alternatively an order for reconstruction of the file may be given. My lord.
Which year matter?
2021, my lord.
21 matter. Right now, nothing can be done. My officer will trace it out.
Well, maybe permit to mention my own application.
Please do not mention any matter for inclusion or upgradation. No.
My lord,
All applications have been accepted.
I'm praying for leave to move this on an urgent basis. My 17th, the CBSE exams will start for class 12. And I have been debarred from appearing in the examination because of lack of attendance. My lord, I was under medical treatment. I had an injury in my neck and my hand. And therefore, and kindly grants me leave. Otherwise, the person will lose 1 year.
It is not much. At your stage, do you think that losing 1 year is going to create any impact? Nothing.
That's
is going
class
to
12.
happen.
Class 12.
12, the child
Kindly-
was unwell. He had an injury. Let him take rest and let
He
him
has
take
recovered.
exam.
He has recovered as of now.
No, nothing.
My lord, only 2% attendance. Kindly grants me leave so that I can file it and move it on an urgent.
File it in the department. Nothing doing. Yes.
Second SLST question dispute matter. I am praying for inclusion in the.
No. If it is nothing. No, please no.
Have your lordship look to Millard file a writ petition and to move it urgently, Millard. What happened, Millard? The petitioner's Millard application for correction of Millard date of birth, Millard in the records has been rejected.
Which record?
Millard in the Madhyamik examination, Millard the admit card. Now, Millard problem is
What is the petitioner doing now?
going to retire Millard headmaster Millard on 28. Initial application was made on 2019. Thereafter,
File it in the department. No leave.
This was wrong.
No leave.
This is code number 14. Unless my lord, your lordship
he will Millard superintendent on 28.
Yes. He had so many years of
No,
service.
This was initial
And
2019. Millard,
but right
two
now-
requisition and the contempt thereafter, Millard order has been passed, Millard on 2nd.
no, nothing. File it in the department. Yes.
filing code number 14.
Nothing doing, sir.
My lord, in this matter, filing my lord, for application, my lord, for transfer matter, my lord, covered by the lordship's judgment, my lord. And there,
Yes. No, I have accepted all slips. No further slips will be accepted.
yes,
My lord, tomorrow your lordship is already hearing the rule challenge matter of SLST. 5 matters has already been tagged. My lord, one more matter, my lord, which will be tagged with that matter.
Yeah.
Great.
Can we request lordship,
What a leakage.
your lordship, previous month, your lordship has taken up the pension matter on day and CPF matter. So that's why your lordship, the previous Monday,
What do you want?
previous only pension 82 years old. That's why I am now mentioned Monday, since your lordship has taken up the Tuesday and Thursday. Previous.
No excuses. I'm not accepting.
No,
Yes.
that's why I could not mention. I disturbed on.
Please. Yes.
Item number 115 of your lordship's list, my lord. The petitioner is a suspended employee not getting subsistence allowance.
Yes.
I am praying for upgradation.
No upgradations.
My lord, petitioner fresh candidate of second SLST examination. Similar order has been passed.
Similar order means?
As for consideration regarding verification stage, SCST candidate, and they have been marked under general 33.
Where is the matter?
My lord, it has been filed. It is in a monthly list.
It is there in the monthly list.
My lord,
Was it not mentioned for upgradation?
earlier it was not.
No.
Please, my lord.
No.
My lord, petitioner is not get house rent allowance since 2014
What is to be done?
for inclusion, my lord.
No, sorry.
Restoration application.
Nothing doing.
Contempt application is also.
No inclusions.
He is contempt first time, my lord.
Call the list, please.
I beg to appear for the petitioner. I've been led by Mr. Bhattacharya.
May it please your ladyship. My lord, on the previous 5 occasions, my lord, adjournment has been sought for. The ground of my lord.
And you went on counting? How
I
many
have
occasions?
the orders, my lord, now.
I have the orders here also.
My lord, I had placed my case. In fact, Your ladyship had passed an order recording an undertaking which was given by the honorable speaker. The order is at page 16.
Yes.
Paragraphs 5 and 6 will be relevant. 5 to 9 basically. I'll place the entire order, my lord. Instant writ petition has been filed by the petitioner number 1, who is a member of the West Bengal Legislative Assembly and the leader of the opposition, and the petitioner number 2, who is also the member of the Legislative Assembly and the chief whip of the.
What is the problem? Paragraph number 7
Yes, yes.
mentions.
Kindly takes note, your ladyship. Now, the Secretary Para 6, West Bengal Legislative Assembly, has mentioned that entry of, this is, my lord, response to the query of the Honorable Court.
Yes.
The Honorable Speaker replies through, my lord, this memo of the Secretary.
Right.
The Secretary of the West Bengal Legislative Assembly has mentioned that the entry of the personal security of all members of the House, including ministers inside the Assembly House precincts, is prohibited, and it has been published in the Bulletin Part 2 from time to time for information of all members. Aforesaid bulletins are applicable equally in respect of all members of the Legislative Assembly. As the Secretary of the Assembly has intimated the learned Advocate General that the security arrangement is maintained equally for all members of the Legislative Assembly, irrespective of their political affiliation, accordingly, the court is not inclined to proceed with the writ petition any further, though the issue of maintainability of the petition was thought to be urged by the learned Advocate General, but the court has not decided the issue. The instant writ petition stands disposed of, with the observation that all members of the Legislative Assembly shall be treated equally. My lord, we communicate this order, my lord, the solemn order, the next page, on the 29th of August. We serve it upon, my lord, the Secretary of the Assembly, the Director General of Police, the Commissioner of Police, Kolkata, and, my lord, the Director of Security. We indicate that attached, please find herewith a copy of the order dated such and such, passed by Her Ladyship, the Honorable Justice Amrita Sinha, in the aforementioned matter.
Page 20, there is a notice.
Now, on the basis thereof,
30th of
yes,
August.
30th of August, they hang up this notice, my lord. This is nothing but a moonshine I have pleaded in the petition. They say that no one will be permitted to enter with their security. Now, your ladyship kindly takes paragraph number 5 and 6 of the contempt application. At page 9, in willful and deliberate violation of the solemn judgment and order dated 28/8/2025, on 4/9/2025, the Honorable Chief Minister of West Bengal was permitted to enter the precincts of West Bengal Legislative Assembly accompanied by her full security detail. At the same time, the security personnel attached to the MLAs of the opposition were denied entry into the assembly premises on the basis of a notice dated 30/8/2025 affixed on the gates of the assembly precincts, stating that personal security of honorable ministers and members are prohibited from entering the assembly precincts. It is stated that despite such notice dated 30th of August 2025 being affixed, the same was a moonshine in as much as the Honorable Chief Minister of West Bengal, who happens to be a member of the Legislative Assembly, entered inside the Legislative Assembly precincts, as well as the Assembly building with her full security detail. Video footages, my lord, we have annexed along with, my lord, the necessary.
Tell me, apart from the Chief Minister, is any other minister getting this benefit?
My lord, it happened on that particular day. We immediately, my lord, brought it to the notice of the Honorable Court, my lord, by way of filing the application, my lord. So whether, my lord, thereafter, my lord, any benefit has been given or not, my lord,
Not
need to take
thereafter,
instructions, my lord.
even on that day.
So that day, my lord,
then-
there has been a violation insofar as, my lord, all MLAs, because it was ordained that all MLAs, all members of the Legislative Assembly, para 9, has to be
Yes.
treated equally.
Right. Apart from the Chief Minister, is there violation complained of against any others?
On that day,
On that-
it was the MLA from Bhawanipur Assembly constituency, who
Yes.
happens to be the Chief Minister,
Right.
who was permitted to enter the assembly.
That apart, you do not mentioned.
No, it is not there in the
anybody's.
petition, my lord. I cannot travel beyond the petition, my
Right.
lord.
So apart from that, you
Yes.
do not.
So this is an act of contempt, my lord. I say, my lord, this has been done, but the undertaking was furnished with an intent to mislead the Honorable Court to pass an order which, my lord, since furnishing of the undertaking, was within the knowledge of the contemners that they will be violating.
No, but then a notice has also been put up.
This
And there
notice,
is no exception.
no, this notice was used as against, my lord, the MLAs of the, to deter, my lord, the applicants who have brought it to the notice of your ladyship, my lord, the act of contempt. On one hand, they say that there is a notice. On the other hand, they say that this notice, for some reason, is not applicable in respect of one of the particular member of Legislative Assembly. My lord, I will be, my lord, referring to three decisions, my lord, because, my lord, the conduct, why I said 5 times it has been adjourned, my lord, adjournment has been sought for. But this conduct itself is demonstrative of, my lord, the lack of solicitude that the contemners have, my lord, towards the dignity and majesty of the honorable court. First of all, my lord, a wrong undertaking, my lord, has been furnished to the honorable court.
All right, I've followed.
Yes.
Yes, then.
So, my lord, I was relying upon. Yes. But the 16. Kindly bear with me for a yes. My lord, first is, my lord, 2020, volume 17 Supreme Court cases, page 528. The relevant paragraphs, my lord, that I will be relying upon. But are, my lord, paragraph number 23 to 25 and para 31.2. 23, my lord, quotes Lord Diplock. It says that it is justice itself that is flouted by contempt of court, not the individual court or judge who is attempting to administer it. It is also important to remember that while considering the question of disobedience of an order, what must be regarded is the letter and spirit of the order together with the bona fide or genuine belief of the alleged contemner as to such order. Now, thereafter, my lord, Rosnan Sam Boyce has been quoted, my lord. I'll be reading, my lord, from the para 9, my lord. 25 has quoted para 9 of this judgment. We are, of course, quite conscious of the fact that the proceedings in the contempt are quasi-criminal in nature, that the law of contempt has to be strictly interpreted, and that the requirements of that law must be strictly complied with before any person can be committed for contempt. However, as we have pointed out, respondent number 1 gave an undertaking based on an implication or assumption which was false to its knowledge and to the knowledge of the respondent number 2. Respondent number 2 was equally instrumental in giving of this undertaking. This implication or assumption was made explicit by the clarification given by the learned counsel for the respondent number 1 as set out earlier. Respondent number 2 was equally responsible for instructing counsel to give this clarification which was false to the knowledge of the both. Both respondent number 1 and 2 have tried to deceive the court and the appellant. In view of this, we fail to see as to how it can be said that they are not guilty of contempt. But this, whether they are guilty or not, my lord, that will come at a subsequent stage. I am, my lord, at the stage of issuance of rule, my lord. Now, my lord, para 31.2, my lord, it refers to Ashok Paper Kamgar Union's case. Section 2B of the Contempt of Courts Act defines civil contempt, and it means willful disobedience to any judgment, decree, direction, order, writ, or other process of a court, or willful breach of undertaking given to a court. Willful means an act or omission which is done voluntarily and intentionally, and with the specific intent to do something the law forbids, or with the specific intent to fail to do something the law requires to be done. That is to say, with bad purpose, either to disobey or to disregard the law. It signifies a deliberate action done with evil intent or with a bad motive or purpose. Therefore, in order to constitute contempt, the order of the court must be of such a nature which is capable of execution by the person charged in normal circumstances. It should not require any extraordinary effort, nor should be dependent either wholly or in part upon any act or omission of a third party for its compliance. So, my lord, these are the paragraphs I am referring to, my lord. I've already demonstrated, my lord, the solemn order, my lord, was duly communicated not only, my lord, to the parties, my lord, but also, my lord, to the persons in charge of security. Despite that, my lord, and despite a categoric observation recording the undertaking given by the Honorable Speaker through the Secretary of the Assembly, and, my lord, the observation made at para 9 of the solemn judgment and order, there has been a willful and deliberate violation, my lord, by the contemners, my lord. But the other judgment, my lord, I did not cite it right now. It states that willful breach of an undertaking, my lord,
All
that
right.
constitutes contempt. But till date, my lord, they have not even come forward with an affidavit to explain their conduct. So, my lord, if it is presumed that they do not intend to file any affidavit, my lord, may kindly hear it out, my lord, and hauls them up, my lord, for contempt. Because apology, my lord, it has to be tendered at the first instance. The conduct itself shows, but how obdurate their conduct is.
All right, let me hear.
Yes. But একটা judgment শুধু দেখি দাও। But only another one more, my lord, decision that I'll be citing, my lord, reported in AIR 69 Calcutta, page 1. No. I'm just referring to para 12, 13, and 14, my lord. Speaks about the conduct of the contemner and the stage at which, my lord, apology should be tendered. Para 12, 13, and 14, my lord. এটা তো 76 to Supreme Court.
Very well.
Yes. And, my lord, regarding undertaking, my lord, I'll just, my lord, cite one part of a paragraph which states that an undertaking given to the court by a person or corporation in a pending proceedings, well, this is reported in AI 1976 volume 2 Supreme Court cases, page 951, basically para 2 to 6, but I'll be referring to para 5 only. Para 5, the quoted portion which starts from where, however, there is an express direction or undertaking in the body of the order, a breach will enable an immediate application for committal to be made.
Paragraph 5.
Paragraph 5, my lord, it's I'll place the entire paragraph, my lord. Before parting with this case, we may refer to Halsbury laws of England, where after citing Dashwood versus Dashwood for the proposition that when a party fails to comply merely with the terms of consent order, the remedy of the injured party is to apply not for committal, but for an order for specific performance or an injunction, and then to base proceedings for contempt on any subsequent breach. The observation is made where, however, there is an express direction on undertaking in the body of the order, a breach will enable an immediate application for committal to be made. In the same volume at page 44, para 75, we find the law thus stated, an undertaking given to the court by a person or corporation in pending proceedings, on faith of which the court sanctions a particular course of action or inaction, has the same force as an injunction made by the court, and a breach of the undertaking is misconduct amounting to contempt. The case before us being a case of a deliberate violation of an undertaking to the court, the effect was the same as that of a breach of an injunction. So, my lord, these are my humble submissions, my lord, but I was praying for issuance of rule, my lord. Till now, my lord, they have not even responded, my lord. And on the contrary, they have been served, my lord, and they have appeared on the 12th of November.
All right.
Grateful to your ladyship.
The matter, my lord, was adjourned, my lord, on 2 or 3 occasions at my instance. because my lord, I intended to argue, my lord, the maintainability of the contempt application on the ground that, my lord, there is no decision. Now, if your lordship may kindly have a look to, my lord, the order of which, my lord, violation has been alleged, where it's at page 16 of the contempt application. First paragraph says why the writ petition. Second is, my lord, second paragraph is quashing of notification restricting the entry of central security forces into the assembly house precincts along with their protectees. Then para 3, submissions made. Para 4 is, my lord, I have commenced argument, but on the direction of the court, the learned advocate general has obtained instructions from the speaker with regard to the applicability of the notification. The query of the court has been replied to by the speaker through the secretary of the assembly, communicated to the advocate general. The same has been retained with the records, copy handed over to the counsel of the petitioners. The secretary has mentioned that the entry of the security personnel of all members of the house, including ministers, inside the assembly precincts is prohibited as it is published in the bulletin part 2 from time to time for information of the members. The aforesaid bulletins are applicable equally in respect of all the members of the Legislative Assembly. As the Secretary of the Assembly has intimated the Advocate General that the security arrangement is maintained equally for all members of the Legislative Assembly, irrespective of their political affiliation, accordingly, the court is not inclined to proceed with the writ petition any further. Then para 8 is very important for me. Though the issue of maintainability of the writ petition was sought to be urged by the Advocate General, but the court has not decided the issue. So the writ is disposed with the observation that the Legislative Assembly shall, that the members of the Legislative Assembly shall be treated equally. My dear Lordship was pleased to, my lord, put a very pertinent question to my learned friend as to whether, my lord, the ministers of the ruling party, whether they are being allowed to go with their security or not. My learned friend chose not to answer. And, my lord, the paragraph 5 is very craftily drafted. All credit goes to Mr. Bhattacharya possibly. Now, please take paragraph number 5. In willful and deliberate violation of the order, the Honorable Chief Minister of West Bengal was permitted to enter the precincts of the assembly, accompanied by her full security detail. At the same time, the security personnel attached to the MLAs of the opposition were denied entry into the assembly premises on the basis of the notice dated so and so, where there is no pleading that, my lord, the treasury bench members were allowed to enter the premises with their full security. Please take note another paragraph, the acts of contempt at paragraph 7. 7A, kindly have a look. These are the acts of contempt. Permitting the Honorable Chief Minister to enter the precincts of the Assembly accompanied by a full security, while the security personnel of the MLAs of the opposition were denied entry. Doesn't say that the others were given, ruling party members were allowed, but oppositions were not allowed. Then B is willful and deliberate violation so and so by restricting the entry of the security personnel attached to the members of the Legislative Assembly of the opposition, thereby not treating the members of the Legislative Assembly equally. Again, doesn't say that the other members of the ruling dispensation were allowed. So, my lord, these, my lord, my first respectful submission is, my lord, unless, my lord, there is a decision, my lord, there is no contempt. My lord, this has been, my lord, decided by the Honorable Supreme Court. And more particularly, my dear Lordship was pleased to record that the maintainability of the writ petition also was itself in question. But your Lordship felt that why go into all this?
I still feel that there is no requirement of going into all these things.
Yes.
Even at the contempt stage.
Right. Right.
And that was the query as to whether the notice that is annexed to the contempt
Right.
application at page
Yes.
20.
20, yes.
Whether this is being applied equally in respect of everybody.
Everybody except the Chief Minister.
Why this exception?
Yes. Now, my lord, this exception, my lord, some exception has to be made.
Why? What
Yes.
is the
My lord,
requirement?
here, my lord, my lord,
Because
but
that
since
is
my lord, I am not in
most
the REIT. Yes.
protected area.
Yes. Yes.
with so many legislators over there, why will one of them feel so insecure to carry the security personnel
No,
there?
it
Because
is not, it is the Speaker, Millard, who has allowed the Chief Minister to enter with her full security.
is
Yes.
it any requirement, or is it just a show that yes, I'm going there with
Yes,
so many?
but that is what, Millard, I intended to argue, Millard, at the writ stage, whether, Millard, this is something which can come within the arena of judicial review.
The court, from the very first day, I say I am not
Right.
inclined to go into this.
Please, that is my submission. Millard. Let the security in the assembly be looked after by the presiding officer of the assembly. Here, Millard, if I am to address your lordship, Millard, on the difference between the chief minister and the other members, Millard, I have those judgments.
Not the difference.
Yes.
This is only security arrangement.
Yes.
If the security arrangement is all right, then there is no
Yes.
requirement.
Well,
Unnecessary, see, the court's time is being wasted
right.
hearing all these things.
Yes, but I would be suggesting that it is best left to the speaker or this presiding officer who is Millard entrusted to look into all these aspects.
And it is you who have to guide the speaker as to how he is to act.
Me.
Yes, the AG. See, these things crop up.
Millard, I cannot say a lot of things which I want to say.
Whatever is required to be submitted in court,
Yes.
you are within your limitations. The court has its own limitations, and let those persons also act.
But could I say this, Millard? Since
Say, if you
since Millard Lordship is pleased to make an observation, Millard, there are, Millard, 4 constitutional authorities over here. The judge, your lordship is referring to me, the AG, the chief minister, and the speaker. 4 constitutional authorities.
And you will be advising 2 of them.
Yes. But all these, at the instance of a person who thinks that he is a constitutional authority, but he is not a constitutional authority.
Maybe.
Therefore, Millard, the purpose is
the person's thinking.
Yes, the purpose is, as has rightly fallen from the court, that one constitutional authority should have, Millard, trust and faith on another constitutional authority. Therefore, Millard, I very respectfully and humbly, with Millard, utmost deference to, Millard, the judiciary, I am submitting, Millard, that leave it to, Millard, the speaker. Let him undertake the activities to which, Millard, he has been entrusted with. Well, please drop the contempt proceeding, but otherwise, Millard, I have to go on arguing that whether there is a list decided.
Judgments are coming for this.
No. I have not placed my judgment.
You have not placed.
Yes.
The petitioner has placed.
Yes.
You will come up.
Yes.
The court has to adjudicate.
Right.
If the court did not adjudicate the writ proceeding, and if the contempt is to be adjudicated,
exactly.
then
exactly. This is what my submission is. Kindly drop the contempt proceeding. If my learned friend wants to a point to be decided, let that be decided first. Whether at all a writ could have been maintained on this. And your lordship was very kind enough to, Millard, record that. The maintainability was raised. Your lordship felt that it's not required. We are not required to go into this. Millard, I would be very humbly submitting, Millard, I don't know why is this proceeding being dragged. But I have my remedies open. But I have not chosen to do that because I did not expect that these kinds of, Millard, what should I say, Millard, the other, Millard, interests in the matter will surface in before the judiciary.
Please come. The petitioner presses the contempt application. Stop. The learned advocate general presses the contempt application and concludes argument. Stop. The learned advocate general commences argument. Stop. Prior to hearing the contempt application any further, the court is of the opinion that the notice annexed at page 20 of the contempt application be applied equally in respect of all the members of the Legislative Assembly. Stop. Hearing of the contempt application stands adjourned till 27th of April 2026.
But may kindly, your leadership may kindly clarify, my lord, all means includes the chief minister, because here, my lord, there is a sufficient.
Mentioned all.
No, that is already mentioned, my lord, in para 9.
Yes.
Despite that, my lord, the learned advocate general has, my lord, categorically admitted that it is applicable as against all but the chief minister, who also happens to be an MLA. My lord, I was just, my lord, praying for, my lord, that limited observation, my lord.
I'm grateful.
Very good. I'm sure, my lord, since, my lord, the learned advocate general is here.
Yes.
So the constitutional authority will be advising, my lord, the
Right.
constitutional authority to act constitutionally.
And somebody who is not a constitutional authority should
No,
not
I'm a litigant. I'm an
think
ordinary
himself to
person.
be a
I'm a
constitutional authority
litigant. I'm availing my rights under Article 226
and trying to apply Article 40.
No, yes, Article 14, absolutely.
Sure. Item 2.
Grateful, grateful.
I'm grateful.
I appear for the respondent number 2. For the review applicant, my lord, this is regarding applicability of that memorandum regarding.
I appear for the Union of India, my lord.
Some query was required from you.
Lordship's order of 13th, my lord, kindly have
Yes.
fixed it. Your lordship
Right.
has asked the union to clarify as to whether
This
the
memorandum.
June 2021 memorandum, office memorandum is applicable in respect of the employees of a PSU only. In this regard, my lord, may I just indicate that when I got this brief, my lord, I had written this email to the Ministry of Personnel and Training, my lord.
And the reply?
And the reply is also here, my lord.
What does it say?
My lord, kindly have a look at it.
Say so that they can also know. what
I'm
it is.
giving them copies, my lord. I have copies.
Mention it. What does it say?
My lord, it says that kindly sees paragraph 2 of this email. In this connection,
Yes.
it is stated that the Department of Pension and Pensioners Welfare is a nodal department for formulation of policies relating to pension and other retirement benefits of central government civil employees covered under the Central Civil Rules Pension Rules 2021. The implementation of such rules, instructions, etc., lies with the administrative ministry stroke department organizations of the employee covered by these. These rules, however, do not suo moto apply to employees of Ministry of Railways, Port Trusts, RBIs, public sector banks, PSUs, autonomous bodies and state governments, UTs, etc. So this is.
Yes, I've got it. See, this cannot be suo moto made applicable, and the PSU says that they are not applying this in their case. So how can you say that it is meant for everybody?
Same point in time, my lord, if I may hand over a copy of the RTA reply, it is
Again,
from
reply.
well,
The Union of India Council is there.
from the ministry, my lord.
Not do.
It's from the Ministry of Petroleum and Natural Gas. My lord, on the right hand column, my lord, on the second column, Ministry of Petroleum and Natural Gas is a cadre unit of the Department of DOPT. Accordingly, all instruction and OMs issued in by the nodal department for pension related matters, that is Department of Pensions, such and such, implemented by this ministry in letter and spirit. The provision constraints such instruction are directly applicable and are being followed as per the extant rules, my lord.
That is for the ministry. No, sorry, sir.
No, that is for the ministry, my lord. Because if your lordship sees the question number 3,
I get it.
Question number 3, please provide the office memorandum, stroke circular, Department of Oil and Natural Gas, where they have adopted this 2021 rules.
Not there.
As is concerned, if it is an instruction by DPE, Directorate of Public Enterprise, that will apply, not for the
Otherwise-
personnel and training.
Please come. Peruse the
नामटा दिया है.
clarification provided by the Undersecretary, Department of Pension and
But
Pension
may I just also
Welfare.
indicate, my lord, if your lordship sees the last paragraph of my
I've checked up.
I have written it to the ministry also,
I have seen that.
but I have not got any instructions from them.
ঠিক আছে? Where from it appears that the government order, not
Office
government,
memorandum.
the office memorandum, which the petitioner submits will be applicable in case of his client, comma, is not suo motu applicable to the employees of the public sector undertakings. Stop. It is only if the public sector undertaking adopts the same, comma, then only the office memorandum becomes applicable. Stop. Paragraph. In the instant case, there is nothing on record to suggest that the public sector undertaking adopted the office memorandum dated 3rd June 2021. Stop. Learned advocate representing Bamalori has categorically denied acceptance of the aforesaid office memorandum. Stop. In view of the above, the court does not find any reason to interfere with the order under review. Stop. The application for review stands dismissed.
Grateful.
There is an application pending that may also be discussed.
In connection with the GA2, my lord.
Connecting application stands dismissed.
Wait.
I'm for the petitioner, my lord. My lord, order was passed by this honorable court on 14th January, my lord. Only small error is there. In point number 4, my lord, in place of group D, it will be group C. With reference to a report submitted by the state and also page number 30 of the writ petition.
D shall read as C. Yes, next.
Grateful, my lord.
My lord, in item number 2, my lord, Mr. Ujjwal is appearing on behalf of the petitioner, my lord. But he has not come to the court today. Certainly, a matter, my lord, was listed before the Honorable Supreme Court, my lord. He's on his legs before the Honorable Supreme Court. I was praying for 1 day's accommodation, my lord. Only accommodation for the day, my lord.
Matter pendency in other court is not a ground for accommodation, right?
My lord,
So you can proceed.
Lord,
There
what
is no
else?
requirement that the matter has to be adjourned.
Lord, Mr. Rai, my lord, is leading me, my lord. He's not
Maybe.
come. He has not come, my lord. I was seeking only 1 day's accommodation.
Very well. The commission was allowed to revert.
My lord, your lordships directed me to take instruction why the petition was not, my lord, granted transfer recommendation in favor of the first preferred school and second preferred school, my lord. My lord, I have received instruction, my lord. The first preferred school was included in the vacancy list for the second SLST. So, my lord, as per rules, commission is not in a position to issue transfer recommendation in favor of the petitioner in the first preferred school. And in second preferred school, petitioner, above the petitioner, there are 5 candidates. Those who have made application prior to the writ petitioner, and 2 of them are medical reason self. So, my lord, if my lord violating, superseding the other candidate, petitioner was recommended. My lord,
What I was praying, my lord, only 1
required
day.
only one correction. Kindly ignore this portion, my lord.
Lord, kindly grants me 1 day accommodation, my lord.
Manushi Shodhar. She applied in 25 and the others in 22.
Yes, my lord.
We are in 26. What is your commission doing?
My lord, since my lord, last three lines, my lord, that since the government of West Bengal School Education Department
Suspended the Uchosri portal. That is
cannot show moto consider the pending transfer application, otherwise, my lord, directed by the court.
pending at the stage of the commission. Any medical reason is serial number 1
Yes,
and serial number 5.
5 my lord. Her application is in the year, my lord, 2025.
Please come.
My lord, kindly grants me 1 day's accommodation, my lord.
Board did not receive any recommendation letter till 5th February, Lordship.
Whatever,
Recommendation stage has not yet come.
my lord, recommended in the third preferred school. Mr. Roy.
That
yes,
is
ma'am.
different.
Yes,
That is different. She is not agreeable to the third preferred
Yes,
school.
madam.
It is only the first and
second preferred school.
that the petitioner wants.
My lord, kindly, my lord, allows me to come back with the instructions, my lord. Lord, what I was requesting, my lord, kindly allows me, my lord.
Petitioner has been recommended to the third preferred school.
My lord, in that even may I take out an
As
exception, my lord.
none of your explanations, excuses to get the matter adjourned will be accepted today. No use making submissions.
I was praying, my lord, 1 day only.
I told you, no use making submission. As the first preferred school has been included in the indicative vacancy list of second SLST. Of second SLST within bracket 80, 2025. As regards the second preferred school, there are 4 other applicants who are senior in the senior as regards the date of making application, seeking transfer. Out of the 4 candidates applying for the same school, 1 is pending consideration since October 2022 for medical reason. Paragraph. It will not be proper to accept the prayer of the petitioner for being transferred to the second preferred school by ignoring the claim of the others who applied earlier than that of the petitioner. Next. As the first preferred school by the petitioner is included in the indicative vacancy list of the ongoing recruitment process, the court is not inclined to pass any direction with regard to the same. As regards the second preferred school by the petitioner, the applications made by 4 other applicants who do not proceed after 2022, after 29th September 2022, in view of suspension of the Uchosri portal. Paragraph there. As transfer is an incident of service, suspension of the Uchosri portal will not stand in the way of the authority, village jaiga ought not to, from considering the applications for transfer stop. Next. In view of the above, the instant writ petition stands disposed of by directing the Commission to call for a hearing of the candidates who are senior in rank as regards the date of the application. Stop. If the call for a hearing among all candidates, bolam to. Hearing of the candidates. Stop. If any candidate senior, not any candidate, if the candidate in respect of serial number 1 who has applied for medical reason. See, medical reason is to be given preference, isn't it? So what is the requirement of hearing the other 3? Because one is pending at the stage of the head of the institution. It's
Malad, kindly direct the Commission to call for a hearing and the pending application on the medical grounds.
Medical ground, there is, I can see only one. So
Yes, madam. Both the candidates, my lord,
only
serial number 1 and 5 to be called.
5. Others, it is no use. Ki bollam? Now, hearing a jayega to call the candidate whose name is appearing at serial number 1. And whose application on self-medical ground is pending consideration since October 2022. Along with the petitioner. Stop. If the other candidate is still willing to join in the second preferred school referred to by the petitioner, then the Commission shall take necessary steps in the matter. Stop. If the said candidate declines to accept transfer in the said school, is it Shantipur High School?
Yes. Yes, ma'am.
Second preferred school?
Yes, my lord. Govindpur girls, second. My lord.
Second number is not there, but then possibly this is the second one.
Shantipur High School HS.
Shantipur High School HS. Shantipur High School HS. Then the petitioner be provided an opportunity to seek transfer in the said school. Stop. A decision shall be taken by the Commission at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. If the prayer of the petitioner is accepted, then necessary consequential steps shall be taken without any further delay. Stop.
My lord, another thing, my lord, kindly turns to page 70 of the writ petition. My lord, this is the transfer recommendation in favor of the petitioner in third paper. It should be stayed for a limited period of time till the decision is taken by the Commission.
That is also my prayer, my lord. I'm sorry, my lord, I could not.
Yes, my lord. Yes, my lord.
The recommendation made in respect of Moukhali, Gopinathpur,
ওখানে জয়েন করবি না তো?
Gaurav Bala, Vidyalaya. Made in favor of the petitioner be kept in abeyance
Till the decision is taken.
till a decision is taken by the West Bengal Central School Service Commission in this regard. It is however made clear that in the event the petitioner is interested to join Moukhali, she may choose to do so upon giving an intimation to the commission. It petition stands disposed of. Hand over a copy to him.
My lord, I'm completely grateful to your
Made a
lordship, my
copy
lord,
of
with
the
this order.
report
But if I
dated
could,
5th of February 2026.
if I just
Signed
could
by
only,
the chairman,
I'm
West
sorry.
Bengal Central School Service Commission. A copy of such and such has been handed over to the learned advocate representing the petitioner.
My lord, I'm grateful, my lord. One prayer, my lord, only one prayer. If I just could take your lordship to, my lord, that your lordship has, my lord.
But I am petitioner is a retired assistant teacher who opted under Open 90. She seeks permission to deposit the government share of CPF to come under the pension scheme. The matter is covered.
Let me see.
Judgment of Muktimoyi Pal De. Paragraph 5, I have stated.
Disposed.
All are appearing for the state, my lord. I am for the petitioner. My lord, kindly turn to page 25. The widow of the deceased teacher, my lord, moved a writ petition for granting family pension. Page 25. Prior to that, my lord, she, after the death of the retired employee, she refunded the entire amount for conversion from CPF to GPF. After the death of the deceased employee. Thereafter, no action was taken. She moved a writ petition. And now the widow has died.
Son has come.
Son has come. Since the amount was refunded, my lord, the order was passed. This has been passed by this honorable court. Only, my lord, after processing the family pension, my lord, to release the arrear from the date of death of. You kindly see the. Only the arrear, my lord, one time arrear, whatever, my lord, calculate from the. Till the death.
Died in 2021. The writ petition is being filed in 25.
2021. Yes.
Yes.
Order was passed on 2019.
Right.
Thereafter, my lord, order was communicated on 2020. Now the 2021 was, my lord, she died. And my lord,
show me the proof that the money has been paid.
Yes, yes. That has, I have annexed, my lord, that is page 19, 18 and 19.
The PPO?
19. No.
19 is certificate
no.
of death.
That is, my lord, 21 and 22.
21 is 1993 or 83.
94.
Teacher
concern, my lord, return the money for conversion. That is the, my lord, 1991 as per government order dated 16 December 1991. This is the.
Where is your PPO?
PPO has not been issued.
Without the pension?
No, pension has been sanctioned.
It cannot be sanctioned.
Because because the teacher concern died on 98, page 19. After the refund of the money, page 98, teacher concern died. After that, my lord, the widow claim for family pension.
Teacher concern died in 98.
98. Just after refund the amount.
What amount did he refund?
Yes, there are two pages, 21 and 22.
Yes.
22, my lord, 98, the amount was refund. Right hand side, contribution and recovery towards pension.
All right.
PPO, my lord, was not issued, but the widow, after the death, my lord, the widow has claimed. Widow, my lord, claimed, my lord, for family pension. She moved the writ petition. Order has been passed.
The employee did not receive pension. How can family pension be issued?
Family pension in favor of the widow.
If the employee was not receiving pension.
No, my lord, that is the, at that time he was not granting pension because he was under CPF. He refund the money. My lord, now after the death of the deceased employee, my lord, widow can claim, my lord, in view of the judgment. But widow moved the writ petition after the objection.
Provided it is found that it is pensionable, then only. What is the instruction?
Well, the instruction is that let them file a fresh representation before the DI.
No, sorry. Where is the written instruction?
Written instruction I have not received. They said that the officers.
No, they saying will not do. You have to show me something. What was the requirement of pages 21 and 22?
Just last page of the writ petition, you will also the school, my lord, submitted all pension papers. That is in 2014.
My lord, at page 36, my lord, there was a letter forwarded by the head of the concerned school to the district inspector of schools. There it was written that this writ petitioner was asked to file the legal heir certificate, my lord.
The legal heir certificate has been issued. I have annexed. And last page you will also can listen.
Please obtain written instruction and revert.
Okay.
The petitioner is the son of a deceased teacher. Stop. His submission is that his father, when he was alive, returned the contribution and recovery towards pension and other retirement benefits in the year 1998. Stop. His father expired in the year 2019. 98. Expired on 16th of May 1998. While he was alive, Bhavana. The teacher did not refund. Somebody else refunded because the date is September 98 and the teacher expired in May 98. While alive, Bhavana. Ki bollam oই লাইনটা? That the contribution of
15 May.
The pension and other retirement benefits was returned.
Satan. This is probably 97.
The petitioner decision is 98.
Returned.
97 housing footage. It's probably 97.
Not 97.
দিল তো নেই 14 সেপ্টেম্বর দিয়েছে না বোঝা যাচ্ছে না তো Not the last page, your lordship, that will be clear. Last page of the DI also has taken steps. Wrote a letter to the school to submit the pen papers. Your lordship, last line, with reference to your letter, by dated such as 15 August 2024.
Which page?
Last page, page 36.
Huh?
School, in reference to the letter of the DI, school wrote a letter to the DI. After legal air certificates, everything, all papers will be submitted. Now the legal air certificate has been issued by the DM.
কি বললাম শুরুটা কি করলাম বলুন তো his submission is that he would be here that the pension which was payable to his deceased father and the family pension which was payable in favor of his mother since deceased be released in his favor. Stop. Attention of the court has been drawn to a communication dated 20th August 2024 made by the headmaster of the school to the District Inspector of Schools, Secondary Education, South 24 Parganas.
Let him make a fresh application with the legal air certificate. That is what I'm saying.
Do you think that the air will change?
No.
What do you mean by fresh airship certificate?
No. There is a fresh air, I do not mean to say a fresh airship certificate. I mean to say a fresh application with a airship certificate.
কি বললাম DI which mentions about a memo number of the letter of the District Inspector of Schools as regards grant of death gratuity and arrear pension. Top paragraph. Prayer has been made to direct the District Inspector of Schools to sanction and disburse the arrears of the terminal benefits of his deceased father. Stop. Learned advocate representing the state respondents is not ready with instruction. Stop. Hearing of the writ petition stands adjourned till 23rd of February. 9th of March 2026. Stop. Written instruction shall be obtained by the learned advocate representing this state prior to the urgent date of hearing.
23rd of February.
Five, I am for the petitioner.
This matter I am for the state, my lord.
Petitioner was initially an assistant teacher, your lordship, just page 26. He joined as headmaster of the school on 16th October 2001, page 26. Now there are, after the joining, since the school was a junior high school, page 27, his pay was fixed, page 27, by the DI of schools. Now the page 28, he joined a school, which is a high school, on 14th August 2007. After joining a high school, DI has the page 29, fixed the pay scale, 9,100 with effect from 14th August 2007. This is the fixation. After the fixation, the ROPA, as per ROPA 2009, page 30 also, the fixation was made. Now the petitioner will retire from service 31st July 2006 to 2026. My lord, the pension papers, my lord, the e-pension papers have been submitted. You also will find page 33.
Yes.
33, middle portion, serial number 18, 9100,
Hmm.
14th August 2007.
Hmm.
That is the fixation. Right hand side approved as HM of high school. This is the, my lord, as per approval of the DI accordingly. Now the pension papers were submitted. Now the joint director of accounts, page 35, raised objection. Fixation of HM high school found not in order. Overdrawn part please be calculated from 1/4/2008. 1/4/2008 means 14th August 2007. My lord, I don't know, my lord, what is the objections raised by the joint director of accounts. My lord, I drawn my salary as per approval of the DI, as per fixation, my lord, the sanction order of the DI. As per provisions, I got, my lord, the increment time to time. No, it is not a higher secondary schools. I received 2 additional increment. It is a high schools. 1 increment has been given to me. Now because of the objections, my lord, the query of the page 36 school has, my lord, submitted a reply. Now I don't know, my lord, what is the reasons, my lord, HM fixation of HM
Who has
was not.
submitted reply or you have submitted reply?
That is because I am a headmaster.
Right.
That is why I have given a reply. That is the what facts has been, my lord, given after fixations, my lord, he drawn salary. He will retire, my lord, 31st July 2026.
But in this matter, I am for the state, my lord, along with Shuddhadev Adok, my lord. I am praying for 1 week time, my lord, for getting the instruction because.
So what were you doing so long?
No, so long means due to my personal problem, my lord, I did.
But then somebody else was there.
Only 1 week time, my lord.
The petitioner is a headmaster of a high school. Stop. He is due to retire from service on 30th of June 2026.
30th of July 2026.
Until July. Stop. He at this stage his pension papers are being made ready. Stop. He is aggrieved by the objection raised by the accounts department, mentioning that his fixation of pay as headmaster in the high school has been found to be incorrect. Stop. He has been directed to refund the amount overdrawn by him. Stop. Paragraph. According to the petitioner, he has received payment strictly in terms of the pay fixed by the district inspector of schools. Stop. The petitioner did not receive any payment which is not in conformity with the pay fixation by the competent authority. Stop. Learned advocate representing the state respondents is not ready. Stop. Release the matter on 9th of March 2026 to allow the learned advocate representing the state respondents to revert with a written instruction from the state respondents.
9th March.
Yes, please.
I am appearing for the petitioner, my lord.
Secondary body lodge.
In this manner, I have the instruction to appear for the administrator, my lord. I have received the Vokalatnama through WhatsApp, my lord, but the physical copy is yet to receive, my lord.
How soon are you expected to receive it?
By Wednesday, my lord.
My lord, same,
Okay.
same is also mine.
It means you are appearing for?
My lord, the private respondent, my lord, Nikhil Mundal and Sitting Mundal. Lord, I have also received Vokalatnama through WhatsApp, my lord. By today, they will forward it through my lord courier.
All right. And 12 and 14 is anybody representing?
No, my lord, as well, my lord, I was appeared, my lord, on behalf of 12 and 14 also, my lord, but they have not given the Vokalatnama.
All right. School is here. What is your allegation?
My lord, may I first straightway take your lordship to the final judgment of the Honorable Division Bench, which is beginning at page 77.
Yes.
There your lordship will be pleased to find the facts. The present appeal has been preferred challenging an order dated 11 June 2025 passed by the learned single judge in WPA 22379 of 2023. Pausing here, my lord, this 22379 is at the instance of, my lord, the guardians, the private respondents here, some of the private respondents here. The said writ petition was preferred by the guardians of such and such a school for issuance of necessary direction upon the respondents to make investigation into the misdeeds of the respondent number 9, that is my client now, not the appellant. If necessary, by initiating appropriate disciplinary proceedings against the respondent number 9 forthwith. The said respondent number 9 was the headmaster of the school who retired during pendency. Records reveal that in the writ petition previously an order was passed on 7th April observing that inter alia the board has not forwarded the preliminary inquiry report and other materials which are available before the board relating to the proposal for initiating disciplinary proceedings against the respondent number 9. Same shall be forwarded to the secretary such and such within 10 days from date by the concerned authority, and on receipt of the same, the secretary shall take decision whether approval is to be granted as contemplated under the second proviso to Rule 5(3) for initiating proceedings against the respondent number 9 or not within a period of 3 weeks thereafter. This matter again appeared for consideration on 11 June, and the writ petition was ultimately disposed of, observing that in view of the grant of approval thereby permitting concerned authority of the board to initiate disciplinary proceedings against the respondent number 9, it appears the grievance of the petitioners stands redressed. Drawing an attention to an order dated 28 January passed by the President Ad hoc Committee of the Board, Mr. Bhattacharya, learned advocate appearing for the appellant, respondent number 9, submits that without waiting for the audit report as called for earlier, the board could not have taken a decision to initiate proceedings against the appellant subject to grant of permission by the Commissioner of School Education. He further draws that about 350 days after superannuation, the Secretary, School Education Department could not have granted sanction in terms of the Proviso 253 of such and such rules to initiate disciplinary proceedings against the appellant by a cryptic order dated 9 June 25, and as a consequence thereof, the appellant's pensionary benefits have been withheld. Such arguments as advanced before the learned single judge were glossed over and no finding was returned. He further submits the writ petitioner, being the guardians of the school, had no locus to prefer the writ petition seeking direction upon the respondents to initiate proceedings against the appellant. Mr. Roy, appearing for the writ petition.
Has any disciplinary proceeding been initiated?
My lord, what has been done is this approval and this report was placed before the Honorable Division Bench. And the Honorable Division Bench felt that since these orders are standing and you have not challenged the orders, you can't challenge it in appeal, you will move a writ petition seeking an appropriate interim order or interim protection. Now, my lord, let us, my lord, since your lordship has understood, my lord, what is the my lord, kindly sees, my lord, first is sanctioned by the government, page 46 of the writ petition. This is post board, my lord, communication. This is 9 June. I'm just reading it. Your lordship need not trouble your lordship's eyes. With reference to the above caption, the undersigned is directed necessary sanction in terms of the rules was granted. Rules to initiate discipline proceedings against Pradeep Mishra. The departmental proceedings should be completed as expeditiously within 6 months. This is 9th of August, 9th of June 2025. And my lord, what we are essentially on is the decision of the president. That was placed before the Honorable Division Bench because that was a part of the appeal papers. And that is also part of your Lordship's papers. My lord,
When
page
did you retire?
My lord, I retired on it is recorded.
30th June.
30th June 2024.
All right. So right now, what is the stage? Only sanction has been granted.
Sanction has been granted, and my lord, on the basis of these findings, my lord, the sanction, according to my humble understanding, is
Could not have been granted.
could not have been granted. My lord, just my lord, take the trouble to kindly come to my lord page 43 once.
What is the allegation against you?
Defalcation.
My lord, alleged defalcation.
Financial defalcation of government fund, midday meal. My lord, students were admitted last 4 years. My lord, none of the amount which has received in the amount of admission fees, my lord, before the bank. My lord,
What is the admission fee?
my lord, 240 rupees, my lord. My lord, I have the audit reports where the government
How many
auditor.
students are there in the school?
My lord, I am for the guardian, my lord, from the audit reports. If your lordships kindly transfer.
The guardian has the audit report and the
Yes.
board does not have it.
Yes.
Very strange.
My lord, if your lordship
Kindly visualize the situation.
kindly see the audit reports, the mark portion, my lord, 3. Admission
Where
fees.
from did you get this?
My lord, I have taken these audit reports from the school authority, my lord. Yes.
Why? What relationship, extra relationship you have with
No,
the
my lord.
school?
Since, my lord, I was made as party respondent, and my lord, these audit report I was seen from my learned friends, in the division bench. So I have requested the present teacher in charge kindly provide me the audit report so that I can.
He is not concerned about his own ward. He is concerned about future of everything apart from his own child who is studying there.
Obviously, my lord. After all, I am the.
One thing. My lord, the board first held in 2023, when the petitioner was very much in service, my lord, board asked getting all these complaints against the HM, my lord, board asked the DI to hold preliminary inquiry. My lord, thereafter, my lord, in December 2023, show cause was issued to the petitioner. Now, my lord, thereafter he replied to the show cause. Show cause with lot of documents given to us. Thereafter, my lord, in April 2024, June 2024, August 2024, March 2021, the board asked the DI to do an audit. It was not done. Why not done, my lord? They have said that due to non-cooperation of the school, audit could not be done. So we have made reminder to the DI on April, June, and August 2024. Now, my lord, during this period, my lord, the headmaster was very much there in the school at that point of time. Now, my lord, during this period, the headmaster retired in the month of June 2024. Now, my lord, after his retirement, my lord, the court directed by order dated 13th January 2025, your lordship, that is at page 55, court directed board to decide whether DP should be initiated or not. So, my lord, what the board did, your lordship? Board, my lord, gave a hearing to all the parties, the petitioner and all the parties.
And that order of the court was not challenged.
No, it was not challenged. Now, my lord, board asked.
Order of the court.
No.
It was challenged. The ultimate order.
No,
was
that is the after hearing order, my lord. Now, when the board directed lordship, court directed, my lord, the hearing order. Yes.
Not challenged.
Initial order.
Initial order at page 55. At page 55 of the Honorable Court. Yes. Now, my lord, board gave hearing to all the parties, my lord. The petitioner chose not to appear in the hearing. So, my lord, what happened in the hearing, my lord? The board have taken 3 decisions. What decision? Number 1, board decided to initiate DP. Second, permission sought from the education department since he retired, because there is a provision that after retirement, if any proceeding is initiated, within 3 years from the date of retirement, a proceeding can be initiated, but subject to permission from the education department. So, my lord, board asks for a permission from the education department, and board also asks for appointment of auditor. So, this is the 3 decisions taken by the board. So, my lord, he is aggrieved by this decision of the board, which is a challenge with your lordship. Now, my lord, the audit report has reached us. Thereafter, my lord, we have not issued charge sheet. My instruction is till date not. We're in a process of doing it. And whether, I don't know whether audit report, what reflects from the audit report, it is upon the authority to decide.
And you have a copy of the audit report?
Yes, my lord, I have, my lord.
How
the board have it?
Report
has been submitted before board.
School,
I've got the
a
audit.
copy?
I've got the copy, ma'am.
Board also have the
Everybody
copy.
has it apart from the petitioner. Against two more allegation is, or he has it and not disclosing it.
Madam, may I submit, Malad? Madam, may I initiation of
This first of all, this disclosure was not made before Justice Chakraborty in the division bench. The fact
has
of this
come
audit,
afterwards.
the fact of this
initiation of
audit,
disciplinary proceedings does not, Malad, the cause any prejudice to the petitioner, Malad, since, Malad, the ultimately, Malad, the disciplinary authority may, Malad, the drop the proceedings, Malad. And, Malad, in terms of Rule 5.3 proviso, Malad, the board has the authority to initiate proceedings within 3 years if it is come within the knowledge. Yes.
The
After 3 years
private
from
respondent teacher
The
is
petitioner is not
private
ready
respondent
to face
guardian.
the proceeding.
Matlab
Why he
private-
to face the
private-
proceeding?
that I can understand.
The proviso says, Malad, that no disciplinary proceedings shall be provided that no disciplinary proceedings shall be initiated after 3 years from the date of alleged misconduct becomes known. to
Kindly
board.
see
This is
page,
table because
page
he
2A.
to the board during his he was in service.
Page 2A of the audit report, my lord. Fees collection discrepancies. Then midday meal.
The documents produced by some outsider, who
Let
locus
the,
is in question.
Let the board and the school file a report. We'll see.
And another thing, not only financial defalcation, my lord. My lord, he has, my lord, submitted a document, my lord, upon forging the signature of the president, using the
document?
fourth signature and fourth seal of the president of the managing committee. That was discovered by the then Honorable Justice, my lord, Vishwajit Basu. My lord, when
He was present when the forgery was taking place.
yes, my lord, it was observed. Everyone was there, my lord.
What is the forgery?
My lord, president he was not in the meeting, my lord. He has used the seal of the president. And my lord, that issue was, my lord, inquired by the district inspector of schools. My lord, I have the inquiry report on the next day. I shall.
He has every.
Why?
All right.
Not very strict.
Because under my instance, my lord,
Kindly
petition has been filed.
just two things. What prompts me to come to your lordship? Please come back to page 44.
Yes.
And the division bench's final order, is 8th of January. And page 44 kindly falls back,
Yes.
Yes, or
Page 44 of the appeal papers.
page 48.
Page 44, paragraph 1. The board waited for the audit report of the school in order to proceed without any doubt in the initiation of disciplinary proceedings against Pradeep Mishra. However, in the present situation, disciplinary proceedings may be initiated. Despite coming to a clear finding that, that the audit could not be completed a little ahead, in paragraph 3. Now, today, a bunch of papers are being handed over to your lordship, at the instance of a person whose interest is only the child, his education, his academic, progress. He is producing documents, the school is not producing. Neither is the board producing. Board merely made this submission, audit report is today there. We do not know what is exactly there, who is producing what. I have a strong belief, that this is a political mudslinging going on between two different groups. And it seems, and I'm very constrained to say that the guardian is so hell-bent. The guardian whose locus is in question is so hell-bent. All questions were kept open for your lordship. I have not yet received provisional pension. I have not, in terms of the division bench, assuming provisional pension papers and everything, that has to be processed.
That is in the
Own contribution of provident
Analysis, page 48.
that also, if the guardian is going
The
to,
order passed by the honorable court in the earlier proceedings, wherefrom it reflects that the official seal of the president
I
was
shall, invite your lordships kindly
used,
turn to page 87, the rules for initiation of proceedings, my lord.
Board
Nothing
has
is there that
decided
for
to
initiation of proceedings, my lord, audit report is required, my lord.
Disciplinary proceeding initiates from the issuance of charge sheet, my lord. After board will
He is
take
a
decision
retired
whether proceed or
headmaster
not.
of a high school. He is aggrieved by the act of the West Bengal Board of Secondary Education, holding disciplinary proceeding against him after his retirement. Learned advocate representing the board submits upon instruction that the inquiry which led to the decision taken by the board for holding disciplinary proceeding against the petitioner took place while the petitioner was in service. Stop. The service rules of the petitioner permits holding of disciplinary proceeding within 3 years after his retirement with the approval of the state government. Stop. The approval from the state government has since been received, and accordingly, the board intends to initiate disciplinary proceeding against the petitioner. Up there, paragraph there, learned advocate representing the school submits that there are several allegations against the petitioner, including defalcation of funds. Stuff paragraph. The petitioner retired from service on 30th of June 2024. What are the terminal dues he received? Provident Fund?
Nothing. No, despite the
He has
division benches may not direction.
not received any of his terminal dues.
DI with the direction আছে.
Stop. Next. Where is the direction of the DI?
Please, the final order. Just please come to me, the last portion, page 81.
81.
However, it is clear the appellate would be at liberty to challenge the sanction. Discipline proceedings. এখানে বলছে এই যে, before the appropriate forum, in accordance with law, in acceptance of the professional discourse.
Where is the direction?
Please see,
If disbursed in the meantime would not prejudice.
80, page 80, last portion.
Yes.
Has proceeded in accordance, Mr. Appearing state as advanced cannot be considered in an appeal against an order, etc. Thereafter.
No mandatory order.
In the meantime, if disbursed, section. Page 82. And urge issues connected with
For
and the acceptance of the provisional pension if disbursed.
There is no
that is the
clear order. There is no order
your
as
lordship
such.
passes the clear order. They have to process it.
Not received anything.
Provident Fund.
The
Provident Fund, provisional pension.
The respondents are directed to file affidavit in opposition to the writ petition within a period of 6 weeks. Reply, if any, within a fortnight thereafter. Stop. Liberty to mention the matter for hearing immediately on completion of the aforesaid time period. Stop. Paragraph. The district inspector of schools, secondary education, which place? Malda. Is directed to calculate the admissible terminal dues which the petitioner is entitled to receive and take steps for disbursal of the same without any further delay.
There is no inquiry till date again.
Not terminal.
There is no inquiry till date. As your lordship
Whatever
is to hold.
I am
Just one sentence more. January 25, your lordship is looking at the board's order. January 25. June 25 is the Commissioner of School Education's approval. Today we are in the month of February, there is no attempt on their part to initiate any proceeding by issuance of a formal charge sheet. As your lordship has laid down the law, charge sheet is elementary for initiating proceedings. Till date, no charge sheet. Till such time the matter is decided, nothing should be proceeded.
There are two FIR. There are two FIR pending against the.
Again, this will delay.
Again,
and he is only entitled for.
Your lordship kindly record that your lordship is not inclined to stay the proceedings or anything. Nothing is there.
I am not mentioned anything.
Very good. As your lordship,
As your lordship entitled to get retirement dues, he is only entitled for provisional pension and provident fund.
Who is he?
Being an officer of the court, it is my duty.
As if I am not an officer of the court, I don't know.
Admitted amount.
You also.
Admitted amounts.
Admitted.
7. Admitted amount in accordance with law. The admitted in accordance.
For private respondent.
Well, 7 and 8 are similar matter. Only the petitioners are different. Mr. Dotto is appearing for the 8. If you take up 8, because Mr. Dotto should appear 7 also.
No, I
Similar matter.
should do many things, but I don't know whether I can, because I am not assigned. Now, only one thing about this has been upgraded without notice to the my learned junior. No notice was given for upgradation. But upgradation notice by nahi hai. I to bolchi. Anyway.
Notice of upgradation not given.
No. I tell you, Lordship, we wanted to give notice to the government pleader because earlier service was there. This is so old matter, we will not take.
We will not take.
No, how do I? They cannot trace back their record who is was there. I am told initially who was there, he is no more.
Is there, he is assisting me.
Your Lordship, my learned friend is appearing 8. Let us take us the 8.
That is. Now that I have come.
7 in item
7
number
similar.
7 is the same party.
Only the petitioner is different.
Shubhendu Vikash, I can see the name of Mr. Shupriyo Chattopadhyay for the state.
Mr. Shupriyo Chattopadhyay is not coming to court.
I think mother is.
His mother is passed.
See, if he comes, then it is all right. Otherwise, somebody else has to be engaged.
Yes.
And I am getting reports on regular basis that the GP office is not accepting notices.
Because Lordship kindly sees, this is a matter of 2016. Now, this Saurav Chaudhary and myself were engaged in 2016. Now, the notice would go to Saurav Chaudhary.
We are not informed that.
At times,
it is very difficult to trace out who was engaged in 2016.
But then you must be having records. May maintain computerized records so that it can be easily received.
Now it has improved to a large extent. But then it is difficult. If it was served upon the advocate on record for the state, then it becomes easier.
Now, how can I know the new engagement?
No, it's not the new engagement.
Oh, how do I know? Unless he, after engagement he gives us notice. No.
Arter file ta dekhi. Yes. Rakhu side mein dekhchi.
Now I tell you, Lordship, factually both are matters. That's same malad. Only the petitioners are different. School.
The other is initiated in 13.
13.
And this is 16.
16.
Even then the
facts are similar. At the entirely because this was pending because unnecessarily, malad, according to me, because of the higher pay scale matter, you also go went up to the Supreme Court, reverted the matter back. All
whatever.
That.
Yes.
Now you see, I tell you, Lordship, the petitioner is a malad honors graduate and postgraduate both in agriculture from Vishwabharati.
Regional School Service Commission, malad, is not necessary.
I think, malad, there is nothing. Subject to your Lordship, my submission. Your Lordships will find their
claim against them.
No, not claim against them. Malad, kindly have a look at your Lordships.
The prayer shows that.
Place korte dao. Tapo korchi. Malad, honors, malad, mark sheet, page 46. And then your Lordships will find honors certificate, 47, 48 MSc certificate.
All right. Yes.
Now, your Lordships will kindly come to page, I think this will be, I just give you a Lordship, 54.
Yes.
This is the recruitment notification. Your Lordships will find column number 3. This is 2007. Assistant teacher in work education. You're also getting it. Kindly see the essential qualifications 1, 2, 3, 4, 5. Bachelor degree in home science or agriculture or Bachelor of Science in computer science, all these. Throughout the country, in agriculture, there is no past degree. All are honors degree. Even Vishwabharati. With these qualifications, we appear, disclosing that. Now, your Lordships will find from my recommendation letter, your Lordships will find kindly page 52 by the commission in 2001. That is also the notification in 2001.
Yes.
Kindly see Papan Kumar Das, work education. Here nothing written in regard to my qualification. Kindly take your Lordships, the next page, page 53. Your Lordships will have kindly see my qualification mentioned, MSc Agriculture. Then your lordships, see Das is entitled to draw the scale of pay as postgraduate. But what we are asking before lordship by way of this petition, delete this portion by way of declaration.
Pass
Graduate. Because I am the honors and postgraduate with this qualification I appointed. I will take your lordships now to the ROPA, what the ROPA says.
No, but then this insertion was there at the time of your appointment.
Well, it's approval.
Yes, so approval of appointment.
Yes.
Right. It was in 2003.
2001, subject to correction.
Why are you coming in 2020, 2016?
Because your losses for higher scale of pay. For higher scale of pay, that's there cannot be any limitation. That higher scale every month I am being deprived. Now your losses, there are two notifications I will show to your losses to the one I have.
Has your prayer been rejected?
No. But
Has it been considered?
No.
Where is your prayer for consideration for grant of higher scale of pay? Page 66.
Oh, no. I tell you losses. Rejection. There is a rejection. I'm sorry, Mal.
Where is that?
That's your page 65.
BSc Agriculture, equivalent of honors, is hereby allowed with effect from the date of joining. Notional increment benefit and such as is existing rules. Where is the rejection?
That's your loss MSc.
What MSc?
Postgraduate scale of pay.
It is not mentioned.
Kindly BSc Agri equivalent of honors is hereby allowed.
Right.
From the date of joining notional increment benefit and such benefit upon Kumar Das as per existing rules. But my claim was postgraduate scale of pay.
You are getting
honors now.
Graduate
Initially given pass, now honors. Now I'm entitled to postgraduate scale of pay as per the ROPA. Because I was appointed with postgraduate.
Which ROPA?
Both ROPA, 2008, 2009. I'm showing 2008 and 2009 because I was in between appointed. You know, kindly take up page 19, paragraph 18. I just I take your losses. I will make it very easy to your losses to what is my complaint before grievance before your losses. Paragraph 18, page 19.
Was the authority at all aware that you are seeking for a postgraduate?
Exactly, your losses. Exactly.
Where is your
I give you
application?
I just. Just
indirect way.
Page 65 mentions about
kindly also page 62.
BSc honors.
Page 62.
62.
Leave aside the first paragraph. Last paragraph. I therefore request you to consider my application for getting the scale up as master degree instead of postgraduate scale up on the basis of that. What they did, they gave me honors, not the master.
All right, so this is the challenge.
I tell your losses the law what says. Your losses kindly look at page 19.
Let the DI consider the law and revert.
That can be done.
No, I take your losses. This has been finalized by this honorable court.
Yes. The petitioner seeks postgraduate scale of pay.
Keep it pending before your losses.
Yes, I'll keep it pending.
Do that.
A reasonable time be given so that.
Yes. The District Inspector of Schools Secondary Education, Birbhum. Impugned communication dated 11th of July 2014 has allowed the honors scale of pay to the petitioner with effect from date of joining.
Notional with notional increment.
May I take your questions? Kindly, one matter is called up. Junior is here.
Yes, sir. The reason as to why the honors graduate scale of pay has been allowed refusing the postgraduate scale of pay is not evident from the impugned communication. Show me the order that you are relying upon. Learned Senior Counsel representing the petitioner relies upon the order passed by this court on 9th July 2024 in WPA 6650 of 2015. Within bracket, Deependu Das versus State of West Bengal and others. In support of the submission that the petitioner would be entitled to the postgraduate scale of pay. Stop. Paragraph. The District Inspector of Schools, Secondary Education, Birbhum is directed to file an affidavit dealing with the aforesaid prayer of the petitioner.
The report in the form of affidavit, my lord.
By 27th of February, released on 16th of March, it will be open for the petitioner to file exception to the affidavit to be filed by the District Inspector of Schools prior to the urgent date of hearing.
My lord, only request I am making, your lordships, kindly both the matters be heard together, 7 and 8. The similar, your lordships will find.
So the impugned communication.
Just a minute. Sure. My lord, here prayer is there, but there is no rejection.
Prayer for grant of higher scale of
Yes.
Page
54.
Please come once.
My lord, if that reply is given in favor, this will govern this case.
This I will dispose. I cannot keep this pending.
My lord, can you then keep it pending till the hearing of that matter? Because if the similar issues are there, factually same, except your lordships not.
আচ্ছা এই 7 একটা রেকর্ড করুন তো
Because
নানা
so long period is pending, man.
Let fresh notice be served in the office of the government pleader. Stop. The petitioner seeks postgraduate scale of pay. Stop. His representation before the District Inspector of Schools, Secondary Education, Birbhum is pending consideration for a considerable period of time. Stop. The District Inspector of Schools is directed to revert with a written report in the form of an affidavit. Written দরকার নেই, report in the form of affidavit. By same date করে দেবেন. Returnable on the same date.
A fresh copy of our GP.
Right here, that I
The state respondent.
that I sought for that child care leave. My daughter and my husband was in Sweden, but I have taken leave from 4th of March, but the date is very important.
Your daughter and your
Husband was in Sweden.
Pradipta De is the petitioner.
Pradipta, Howrah. My lord,
No, it's all right.
my lord, I sought for leave, childcare leave, my lord, from 4th of March 2020 to 31st of May 2020 to my lord, go to Sweden to help my daughter for examination. My lord, I submitted my application on 17th of February. My lord, no decision was taken by the school. So, my lord, after 4th of March, my lord, I left for Sweden. But because of the corona pandemic, which started from 20th March, my lord, I could not able to come back from Sweden because all the flights were cancelled. But I reached India on 22nd of February 2020. And on that day itself, I joined this school. But your lordship is aware that the Indian government at that point of time framed a policy to bring back the Indians from foreign. And there were special flights. Now, because of this delay, I could not able to come back to India from Sweden. The corona pandemic, due to corona pandemic, from 22nd March, the lockdown was declared. Now, my lord, the difficulty is that, my lord, my leave has not been sanctioned. If your lordship kindly have a look to the notification once, page 48.
What is the stage of your application?
My lord, the application, according to the report filed by the DI, if your lordship kindly have a look to the report of the DI, where the DI has stated at paragraph 3 of the report. Page 2. I say that the report of the school authority meeting resolution, as per the report of the school authority meeting resolution of the school dated 21st of January 2021, the school authority sanctioned those leaves without pay.
You want it with pay?
Yes, but I could not able to come back because of the special circumstance. The flights were not available. Now, the kindly have a look to my application on 17th of February 2020. I made the application to the school. The school has taken the resolution.
Application date?
17th of February 2020.
Page.
Kindly have a look to page. Just a second. 17th of February, page 24. Thereafter, there was a blank. That is why page 25 I have mentioned once. This is the joining report.
So 24 is blank and 25 is dated 22nd of December.
When I
after you come back,
after I came back.
So 24 there is no date.
But 24th March 2020.
2020.
But
May.
Yes. Kindly have a look to the receiving date, 17th of February.
Yes.
The school has received it.
Hmm.
It was mentioned 17th of February. But I mentioned it. I could not come back on May 2020, page 25 I'm reading. As per my previous application for leave, for the pandemic, all commercial flights to India are closed. So it was not possible for me to fly back to India.
Is anybody there for the school? Because this decision was taken by the school.
Well, it is the leave which if your lordship kindly kindly have a look to page, but the notification starts from page 47. The CCL notification. 17th of July 2015.
Yes.
That I now after careful consideration, the governor is hereby pleased to decide to extend such benefit to this Wanso. Admissible, 2 children up to 18 years. My daughter was in class 5 at that point of time. Total 730 days of leave. Well, got it? Second line from top. I may avail 730 days of leave. Now, this notification was partially modified, page 49. Page 50 is the important part. Second proviso. I have got it, page 50. Second proviso. Provided further that in exceptional circumstances, the leave sanctioning authority may extend such leave, that is childcare leave, in a spell up to 120 days. So, this is an exceptional case where I could not come back. I am entitled to get 120 days leave. And my leave application, which was forwarded to the school on 17th of February, this was considered by the school on, according to the DI, 21st of January. So after 1 year, this was considered. My application was considered after 1 year. And the DI has also annexed the managing committee resolution. Page 5. But got it? Oh. But I sought for extraordinary leave because this is a situation where I could not able to come back.
What is the stand of the DI?
My lord, we have already submitted our report, my lord, before your lordship, my lord. The relevant paragraph is, my lord.
That has been read out. Paragraph number 2, as per the report of the school authorities, and the resolution is annexed. Right.
My lord, when she left, my lord, without any permission of the school authority, she left, my lord, on India on 8th of April 2021. Subsequently, my lord, as per order of the school education department, managing committee of the school.
21. This is a matter of 2020. The leave period is from March till December 2020.
My lord, 1 minute, whatever. That to 21, 25.
No, joining report is page 25 of the writ petition. I came
Yes.
back on that day.
On 8/4/21, communicated dated 5th of April 21. On 8/4, the petitioner left India for Sweden, and the communication dated 13th of April 2021. Paragraph 7, তাই তো এটা?
But I left India for Sweden for 3 times. But the main problem is that part.
It is, we are considered only for the period 4th of March 2020.
Yes.
And it will be maximum for a period of 120 days.
120
days.
It nothing more than
No,
the
it cannot
petition
because of the extended rules.
cannot travel beyond whatever is there. And according to the amended provision, 60 days is the in one spell, but in extraordinary circumstances, it may
120 days.
120 days, not more than that.
Yes.
My leave may be regularized according to that.
Did you implement this school as a party?
The school?
Yes, the headmistress is a party.
The school is a party.
Are you still there in service?
Yes. But may I only request your lordship? This is regarding leave, but of 120 days. If a lordship kindly remand the matter to the DI, DI will call all the parties and the issue may be settled over there. Yes, more than 730 days leave, the board has the power. But 120 days leave, the school has the power.
This is the reason the court wanted to hear the school. But if you want to go back to the DI,
but I have no problem.
Then it can be done. Secretary Actor report this.
Yes, the stand of the school is before your lordship.
You are filing it now? What have you stated over here?
Lordship, I annexed, Lordship kindly come to page 9, Lordship. Provided further that the exceptional circumstances, the leave sanctioning authority may extend.
No, that the petitioner has read out just now. Do you have anything else to say?
Lordship. I just referred this memorandum, Lordship.
Kindly have a look to page 46 once of the writ petition. The school has approached the commissioner. Apply to be unable to guide about joining in the service of Pradipta De, assistant teacher of Raghunathpur Girls High School. The school has approached the commissioner.
Please come.
Lord, one submission is this, my lord, that the managing committee has taken the decision. So school's, my lord, presence is required in this matter. School ki to copy service করেছিস তো?
Learned advocate representing the petitioner fairly submits that the instant writ petition be restricted for regularizing leave with pay for 120 days on account of childcare leave under exceptional circumstances for the period 4th March, for the period now, with effect from 4th March 2020. The petitioner, paragraph D, remained absent from school on and from 4th March 2020 to 21st of December 2020. She has a minor daughter. Stop. She applied before the school managing committee for grant of leave she applied before the managing committee on 17th February 2020 for grant of leave on and from 4th March 2020 to May 2020. Stop. She went to visit her husband. Your daughter also stays there?
Yes, there.
And daughter in Sweden, but could not return to the country in view of the restrictions on account of the pandemic situation. Stop. Immediately on return, she applied for joining on 22nd December 2020. Stop. The school has granted leave to the petitioner, but without pay. Stop. Paragraph. Learned advocate for the petitioner refers to the finance within bracket audit department memorandum being numbered 5560 hyphen caps F within bracket caps P dated 17th July 2015. And the memorandum number 6444 hyphen caps F within bracket caps P dated 27th August 2015 relating to child care leave of female employees. Stop. The petitioner submits that she may be that leave for 120 days may be allowed to her with pay by treating the circumstances as exceptional. Stop. Paragraph. Learned advocate representing the state respondents relies on the report affirmed by the Assistant Inspector of Schools, Secondary Education, annexing the resolution of the school authority dated 21st of January 2020, which mentions about the leave without pay, which was approved in favor of the petitioner. Stop. Next. Report filed by the Secretary of the West Bengal Board of Secondary Education in court today be also retained with the records. Not also, be retained with the records. Mentions that leave can be regularized for a spell up to 120 days only in exceptional circumstances. As the paragraph, the school is not represented, comma, the matter cannot be decided conclusively. Stop paragraph. In view of the above, the instant writ petition stands disposed of by directing the District Inspector of Schools, Secondary Education, Howrah, to grant an opportunity of hearing to the petitioner and the school authority for arriving at a decision as to whether the period mentioned herein above can be treated as exceptional circumstances for approval of leave, childcare leave, with pay to the petitioner. Stop. The government memoranda mentioned herein above shall be taken into consideration at the time of taking a final decision by the District Inspector of Schools. A decision shall be taken in the matter at the earliest, but positively within a period of 12 weeks from the date of communication of this order. A reasoned order shall be passed and communicated to all the parties. Stop. If the leave of the petitioner is allowed, comma, the necessary consequential steps shall be taken by the respondent authorities without any further delay. Disposed.
Grateful.
Grateful, my lord.
The 10 I appear for the petitioner.
Secondary board. No.
10 I am for the private respondent, respondent number 18.
Exception. I'm filing my exception. But I start with the
exception to
the report filed by the commission.
Commission.
Yes, may I file?
Yes.
Let I start with the case manner with the exception and the
Prior
report
to
of
that, my lord, I raised my lord a preliminary objection for maintaining.
Let me just understand what the matter is about and then I'll
that
hear
it's
you.
a very short matter where my lord, if your lordship kindly takes up the report of the my lord, commission once. I will not take more than 2 minutes of my lord's time. My lord, the commission has mentioned in paragraph 4 and 5.
Yes.
My lord, may I read it for your lordship, my lord? On all 3 occasions, the applications my lord, got it?
Mhm.
Were returned back with the same remark. It was my application. No vacancy in the preferred school. The first application reached the commission on 11th of October 2021 and was returned on 28th November 20, 20, it should be 21. 21. The second application reached the commission on 30th of November 2021 and was returned on 30th of January 22. The third application reached the commission on 15th of February 22 and was returned on 26th of June 22. Then the petitioner has raised allegation against one Partho Pratim Boidya, Mr. Jana is appearing, who was the headmaster of Kalikapur Ramkamal Vidyapith, Sonarpur, whose application under the Usosri portal reached the commission on 17th of March 22 and was recommended for transfer in Jadavpur Vidyapith on 4th of April 22. The application of Partho was made on 13th of February 22 on the ground of spouse medical reason, serious gynecological problem. Then it may be noted that the first 2 rejection of the petitioner on the ground of no vacancy on 28th of November 21 and 30th of January 22 respectively were clearly justified as vacancy in Jadavpur Vidyapith occurred only on 1st of February 22 due to the retirement of the then HM of the school. Thereafter, the private respondent number 18 Partho Pratim applied for transfer on 13th of March 23. This is 2 days before the petitioner's application reached the board to the commission from the end of the commission on 15th of February 22. So the only point is, both of us opted for one school, Jadavpur Vidyapit. According to the board, according to the commission, my application was 2 days late, and the Mr. Jana's application was 2 days prior. That is why my
You
case
want it on medical ground?
No, normal.
The private respondent wants it on medical ground, so medical ground should be given preference.
Absolutely, but
Yes.
there is a but.
Yes.
Why I have come to your lordship, with the exception. The exception is very important. Can I have a look to the exception? Copy that.
Yes.
What I have mentioned in my exception. In the exception, I have noted. Copy that. In the exception, if your lordship kindly have a look to the chart, page 8. It is my chart. Kindly have a look to page 9, 6. First, it was forward column number 6. Got 10th of February 22. I applied. Applicant to HY. Then HY on 11th forwarded to DI with the remark, managing committee has no objection if Amal Das Karmakar avails for better chance. Then on 15th of February 22, the DI has forwarded it to the commission for taking necessary action. Backward, 20th June 22, commission to DI. Prayer is returned due to no vacancy in preferred school. Then 21st, DI to HY, general transfer, prayer is returned due to no vacancy. Now your lordship kindly see both the reports, the report of the SSC and my document side by side. The date which has been mentioned by the SSC and the exact document are not matching. Page 4. The first application, I am skipping all this.
First vacancy occurred only on 1st of February 22 due to the retirement of such and such. 1st February 22.
So after 1st February, my application will be considered. 10th of February, I made the application.
10th of February.
Yes. And Partho made the application on 13th, paragraph 6. Got it?
Paragraph 6.
Partho applied for transfer on 13th of March.
13th of March. So it's after you. How
Hmm.
come it says it's... Is it 22 or 23? The dates, I do not understand. What is this? Is it 13th of March 23?
22.
22, it should be 22.
If it is 13th of March 22, I take it for, I take it as 22.
No, recommendation 4th April 2022.
Very good.
That is
Not a 13th of March. I take it as 13th of March. But if 13th of March, that too, my application is prior. This is number 1. Number 2. Now your lordship kindly have a look to paragraph 4 of the commission's affidavit. Now the records. Serial number 4, forwarded from DI to SSC, 15th. The third application reached the commission on 15th.
Assuming his application is 2 days delayed.
Yes.
Assuming. Even then, since it is medical ground, it has been given preference.
My application hit the portal 2 days prior. His application was not in the fray at all. How they will come to know that what is the ground on which, if this is so, if this is medical ground, then why this private respondent has opted for a distance which is far away from his actual place of posting? The earlier school. The earlier school.
When was your application made?
That is the 13th, 9th March.
9th March. Yes.
9th of March.
Apply for transfer.
Then this date is mentioned in the
13 March.
report wrongly.
13th March.
Because petitioner's application is 10th of February.
9th March.
Then petitioner is an earlier applicant, is a prior applicant.
Much prior. February. 10th February is 9th March.
1 month delayed.
Yes.
How do you get a chance then?
No. When the return, my lord, the page 6, page C, my lord, the serial number 6, petitioner applied on 10th February. That was forwarded by the DI on 15th February. I don't know whether the vacancy was reported, my lord, because the vacancy was occurred, my lord, due to retirement of that
Yes.
vacancy.
The
Probably-
dates are mentioned.
And only one thing, my lord, may I submit? Petitioner applied for transfer. My lord, your lordship will find, my lord, the page 54 of the writ petition. He submitted an application for transfer from Paschim Medinipur to Jadavpur.
That is different. You
That
do
is
not
the-
have anything to say.
He has taken false statement, 49 kilometers.
That is not the ground why his application was not allowed. Positive ground is no vacancy. 3 dates are important. The date of the occurrence of the vacancy, his application and your application. Nothing more than that. Commission, what are the dates?
My lord, before the dates, may I explain how the portal operates? How the that I have stated in detail in the report also.
Which paragraph?
My lord, paragraph 6 at the bottom, the 3 lines. It is not first come, first serve. An application might be pending before the commission, and another application is just being made before the HOI. If the candidate before the HOI, the moment it enters, if it is of a higher requirement or a higher rank, then it will automatically block the candidate before the commission.
How? Automatic, what does automatic
The
mean?
entire system is automatic. You make an online application, your calculation of rank, everything the computer is doing, nothing manual. It appears everything is manual. Commission will recommend, DI will forward, but nothing is happening physically. Let me just read 2 pages from my affidavit. Page 4, paragraph 6, the last 3 lines at the bottom of the page. Each applicant for a particular school in a particular subject is assigned a score by the system auto-generated score. I put in my particulars, the computer is calculating what will be your score and ranked according to the ground cum score system. The ranking.
Phone is ringing and it's disturbing.
No, petitioner first applied 13 February 2020.
1 minute, let him read once.
Let me first explain the system, then the dates we can all clarify from the documents. The ranking is also auto-generated by the system. Therefore, a candidate with medical self, kindly let me read this very slowly. A candidate with the ground medical self and say score 10, these are hypothetical scores I'm giving, will be automatically assigned a higher rank than another candidate with ground medical son, daughter, spouse, and say a score of 15. The second candidate in turn will rank higher than a third candidate with a score 20 who has applied under the PH ground. So score is category wise.
I didn't get it. First line, therefore, a candidate with the ground self-medical,
yes,
and a score say 10,
10
will be automatically assigned
given
a
first
higher
preference over
than
a
the
candidate who had score 15, higher score, but the medical ground was of the spouse.
Right. So
Family members' illness is a ground, but it does not affect the teacher while traveling or anything. It is only when I have a self-medical difficulty, then, so the self-medical difficulty is given first preference, though the scoring is lower. So I have to exhaust first self-medical first, then I start with the spouse or child's medical.
So even
that
if,
has to be exhausted. Only after that I start with the PH.
So even if the score is less, as the hypothetical numbers have been mentioned 10 and 15,
yes,
my preference is more if it is self-medical.
Yes,
ground.
yes. Now the other issue arises that I just said that it is not first come, first serve. Kindly come to the next page. The same paragraph is continuing. The last paragraph just above paragraph 7. It is also pertinent to note that the first rank candidate will block others irrespective of whether his application reaches the end of the commission or not. Therefore, even if the application of the said candidate remains pending at the HOI's end, he will block others as mentioned above.
And this is all auto-generated.
Everything.
So there is no human intervention.
No human intervention. At the end, whoever succeeds, a submit button comes up, that too automatically, which is once that is taken, the vacancy is erased. That is how it is developed, the system.
Yes.
And we are only the user.
No human intervention.
Now, may I reply to this? But if your lordship kindly have a look to the rules.
Just
The rules
add to that just 1 minute. My first application on 3rd March, 9th March 2020. That was the orthopedically, I was the orthopedically handicapped. But my orthopedically handicapped was not recommended. 3rd March, when at the moment I applied, vacancy was blocked by this commission. Second application, on spouse grounds, gynecological disorders. That application was made on 9 March 2020. So that was proceeded by the commission on the basis of the vacancy.
All right. Yes.
Let kindly see the dual play. The person himself submitted his application on his own medical ground that I am medically unfit. From Mr. Jana, no record is before
March.
your lordship. 9th March. Now, the moment it was nullified, he takes up the point of his wife, medical illness of his wife. Second point, on 10th March, my application is on 10th of February.
But not on medical ground. This is
May not be on medical ground. May I kindly allow me
what
for
further?
My application was 1 month prior.
Even then it cannot be done because it is auto-generated. Where is the human intervention? You show me.
But kindly have the point or the score number that has been mentioned by
So
Dr.
that is all hypothetical.
Yes, but there is no such rule. I have given your lordship the rule.
The system has been how it works.
My application hit earlier.
No, it's not on first come first serve basis. There is no priority. This is the submission.
Submission
This is actually how it functions. If you can show that no, it functions otherwise, and there is a scope for human intervention, that first
but
come
the
first
report
serve
and the
basis.
documents are not matching.
The dates are not matching.
Maybe, but it is very important. Only one date is not matching, but the other, my first application.
The petitioner's application seeking general transfer. Was not considered on the ground of non-availability of vacancy. Stop. The petitioner is aggrieved as the private respondent's application seeking transfer on medical ground made approximately 1 month after the petitioner applied for transfer stood allowed. Stop. Paragraph. Learned advocate representing the commission relies upon the report affirmed by the Assistant Secretary of the Commission, mentioning that the Uchosri portal functions on an auto-generated score, and the applicants are ranked according to the within quote ground -score quotes complete system. It is the submission that there is no human interference in the system on and from the time an application for transfer is submitted in the online mode. Stop. An applicant seeking transfer on self-medical ground gets the highest score. Stop. Stop now, comma, followed by a spouse, comma, child's medical ground. Stop. Paragraph. It has been submitted that as the private respondent applied on spouse medical ground, comma, the vacancy in which the petitioner applied for earlier got blocked. Stop. The commission does not have a role to play in the matter. Stop. Paragraph. Learned advocate representing the petitioner stresses on the fact that the application for transfer made by the private respondent was a later one and the prior one made by the petitioner ought to be given preference. Paragraph. It is the specific stand of the commission that the system does not work on first come, first serve basis. Stop. As the application made by the petitioner was as the petitioner applied for general transfer, accordingly, the petitioner got a less score, for which the applicant applying on medical ground superseded the petitioner. Stop. Next. Upon hearing the parties, comma, the court does not find that there is any malafide or illegality in the online system of functioning. Stop. Next. In view of the above, no relief can be granted to the petitioner in the instant case. The writ petition fails and it's hereby dismissed.
Can it be disposed of?
Only one thing records, my lord, the petitioner has already joined in 2022. Respond number 8.
Affidavit filed by the and the reply thereto by the petitioner. In court today be written with the record.
This can be, my lord, recommendation, transfer and joining. His service has already been approved in 2020. Kindly record.
Be it record.
Respond number 82.
The transfer of the private respondent in the transfer, that the approval of appointment of the private respondent in the transferred place of posting already took place in 20. Which?
With the recommendation, last page, my lord, the approval of
on 13th of April 2022.
Lord, I am for the state in this matter, Lord.
Yes.
Great.
My lord, in a matter on 5th February, if your lordship remembers, due to a breach of undertaking, your lordship was pleased to restrain a party from carrying on construction. My lord, the order has not yet been uploaded. My lord, they're carrying on the construction. Your lordship directed me to communicate
5th of February.
on 5th of February, my lord.
Today is 9th. It will be uploaded. You give a little bit of time.
They are carrying on with the construction. That is the urgency.
Carrying on with the construction since November or October or prior thereto.
After the order also, my lord.
Yes, so give me this much of time to correct and sign an order. In the meantime, the weekend was there and today is the first day after the weekend. So second half I won't sit. I'll correct orders, sign it, upload, and then tomorrow morning I'll sit. All right. What? Yes.
Lord, I apologize.
No, Lord, it is Lordship.
That I am for the petitioner. It is transfer on self-medical ground pending at the end of the commission. That kindly see page number 32 is the status. 29 September 2022, it has forwarded to the commission on the medical issue and it is pending before the commission.
Whose medical?
That's self-medical, person's own medical.
All right, disposed.
Great.
But I'm for the state.
Not I for the commission. Not I am for the commission.
For the petitioner, my lord. My lord, the petitioner made the transfer application, which was rejected on a single teacher ground, my lord. My lord, the status is on page 15(1), my lord, annexure P5. My lord, kindly see point 12, my lord. Only the last application was not
Please come. The petitioner seeks transfer. Stop. Her application stood rejected by the head of the institution with the remark incorrect BMOH certificate. Stop. Paragraph. The petitioner presses for transfer. Stop. Fresh application to be made.
My lord, kindly consider the rejection, my lord, impugned rejection dated 3rd September 2021, my lord.
Why will it be considered?
My lord, kindly see the prayer, my lord.
Why will it be considered? There were other applications which stood rejected on other grounds.
Petitioner is a TET qualified candidate. He appeared, he applied for for recruitment process in 2016 in upper primary selection. But she was not asked for interview.
She was not
asked for called on for interview.
Yes.
Then this honorable court give an opportunity to all the candidates whose name has not been included in the interview list to make a representation validating their grievances. And according to the in following that judgment, I made an application to the commission, which is at page P8, page 54. But the commission uploaded the date of hearing when the petitioner was seriously ill. Thereafter, petitioner along with her father went the school service commission office and submitted an application and stating her condition that she was ill, which is available at page 61 of my writ petition. I want my grievance should be considered in any way.
All right, please come. The petitioner participated in the 2016 upper primary recruitment process conducted by the commission. Stop. She is a TET qualified candidate. She is a TET qualified candidate, but was not called for interview. Stop. Pursuant to the leave granted by
TET qualified and trained candidate.
Honorable Court.
Trained candidate. Trained candidate.
TET qualified
and trained candidate.
Trained TET qualified candidate. Show me the court's order.
Court's order as at page, Lordship, page 46. Page 46 and except P7.
Okay. Which portion?
Lord, your lordship, first page, the last paragraph, for taking care of the grievance of the candidate whose names have not been included in the interview list, the commission should make an arrangement for giving a personal hearing to the candidate who would file a representation individually, not jointly. The representation containing the grievances has to be filed within a period of 2 weeks from the date the email or
All right.
My lord, that was done.
Court on 9th July 2021 in WPA 10789 of 2021 within bracket Obhijit Ghosh versus the state of West Bengal and others, comma, the petitioner filed a representation which was considered by the authority, by the commission, and a date of hearing was fixed. Stop. Paragraph the petitioner alleges that on the date of the hearing, she was unwell, for which she could not attend. The petitioner made further representation and seeks a direction upon the commission to permit her to appear in the interview. Stop paragraph. Upon hearing the submission made on behalf of both the parties and on perusal of the documents placed before this court, it appears that the petitioner was directed to appear for hearing in compliance of the direction passed by the court in the year 2021. Stop. The petitioner, comma, for petitioner, comma, allegedly for medical reasons, comma, was unable to appear. Stop. In the meantime, the recruitment process concluded and the panel expired. Stop. Paragraph. The instant writ petition has been filed in the year 2023 and today there is hardly any scope to allow the prayer of the petitioner for a further interview. Stop. Next. In view of the above, the no relief can be granted to the petitioner in the instant case. The writ petition fails and is hereby dismissed.
Most probably the panel has not really expired, Lord. It is division bench on Lord 25, Lord. Finally, Lord, it has been decided, and
the panel will remain pending for eternity.
No, Lord. The final, Lord, the division, honorable division bench, Lord. Well, in this matter, I am for the petition. But I am having affidavit service. Well, in this matter, petitioners praying for notional appointment for the petitioners, my lord. Well, kindly see first, my lord, page 33, annexure P4. This order passed by the Honorable Justice Ruma Pal, my lord.
Yes.
Page 36, can you see, my lord? And the petitioner's grievance is that the DSC, being the respondent number 3, has been filed to consider the petitioner's case as recommended by the DI on 18th June 1996, being annexure D to this writ petition. The case of the petitioner is that he has been servicing in the post since January 1979. The petitioner has created vacancy, various discussions of the court and support of his submission that he is by virtue of such long servicing entitled to be absorbed against the vacancies. And this is thereafter this petition is considered. And thereafter, my lord, kindly next page 46. Page 46. No, I believe. And thereafter, just consider, my lord. Page 46, consider with effect from 1/9/2006. And as assistant teacher. My lord, kindly see page 46. Then, my lord, he give a representation, page 48, annexure P9. my lord, prayer for national benefit in the post of since 1/6/1979 considered certain.
Yes.
Thereafter, he moved the writ petition, my lord. My lord, page 50, annexure P10. And there's the petition given direction to consider my grievance. And then, my lord, Honorable Justice Somati Chatterjee. And thereafter, my lord, he passed the impugned order, annexure P11. And after this impugned order, I challenge before this honorable court, Honorable Justice Saugata Bhattacharya passed this order, my lord. Page 59. And kindly see last paragraph, page 10, my lord. Paragraph 10, my lord, page 63, my lord. I am reading, my lord. However, considering that the petitioner, since he is not getting retirement dues after superannuation 31st January 2013.
How many days service did he
Yes,
get?
I have service, my lord, 1st September 2006 to 31st January 2013. 6 years, 5 months. Yeah, about
5 years, 4 months. Length of service.
6 years. Then, my lord,
Was
honorable court,
September 2006 to?
31st January 2013.
All right.
Thereafter, honorable court has given direction to file a fresh representation, and this representation will consider within 4 weeks. Can we see paragraph 10, page 63?
Yes. Then what happened?
Thereafter, I made a representation before the authority, page 65, P13, my lord.
Yes.
And this representation is pending before the authority, not considered, my lord. My humble, as per order of the honorable court, this representation, but not consider this representation, and also one judgment favor our court, judgment it is also favor in mine. This is my humble.
Petitioner cannot get national benefit as he joined in 1st September 2006 and retired on 31st January 2013. Only served for the 5 years 4 months. As per the TCR rules 1981.
But then he was in service prior there too, unapproved service.
Yes.
Why will you not take that into consideration?
That is no rules, my lord. There are already DCRP rules 1981. He have to serve a minimum 10 years. Then he or she is the.
What is the proof of your service?
1979, my lord, to service, and thereafter, my lord, Honorable Justice Roma Pal was passes on that.
No, that I have seen, but what is the proof of your service?
Yes, annexure P1, my lord. Annexure P1. Annexure P1, can you see?
First September 2006, you say you joined. Where is your appointment letter?
My appointment letter is, my lord, page 46, my lord. Page 46, P7.
Post approved on 1st September 2006.
Yes.
Prior to that, you are working in an unapproved post.
Yeah, that time was unapproved.
Then show me how they can accord approval to you or service in an unapproved post.
My lord, according to Honorable Justice Roma Pal, this order was passed, my lord. Kindly see this order, page 36, my lord.
Yes.
Page 36, the order.
To consider and dispose of.
Yes, my lord. That
Nothing more is there.
means I am working since 1997.
In an unapproved post.
Yes. That
post was not sanctioned.
That time was post not vacant, matter. But
There was no post.
Yes. That time. And thereafter, my priority national benefit given, currently I will entitle family pension. Otherwise, not very problem, time the.
I can understand your problem, but.
He has 8 months shortage.
But he is there from such a long period of time.
As per court direction, but he already gets a join in 1st September 2006.
There also another judgment was passed, our division by Honorable Sri Ganguly and Tapan Kumar Datta, my lord. My lord, kindly see page 96. Now, this judgment covered this petitioner. He was working in the year first page 96, my lord.
96.
Kindly see this judgment.
Yes.
This is the judgment, my lord.
Hmm. Show me better decisions in your support. Otherwise, it will be difficult.
So let it be considered and dispose of this matter.
Only consideration, it will be again rejection. The authority has already formed an opinion, has forwarded it to the learned council. Why don't you come prepared and you bring further judgments to show that your post, you can get notional benefit in an unsanctioned post also. All right.
Yes, madam.
Please come.
Yes, madam.
The petitioner seeks notional benefit. Stop. He retired from service on 30th of January 2013. And he claims 31st. And he claims that he is in service since 16th of January 1979.
Yes, madam.
Stop paragraph. The service of the petitioner stood approved from 1st September 2006. Stop. He prays for notional benefit. Stop. Learned advocate representing the state submits upon instruction that as the petitioner did not qualify the service period reckonable for grant of pension, accordingly, pension cannot be directed, accordingly, no benefit can be accorded to the petitioner. Stop paragraph. From the documents annexed to the writ petition, it appears that the service of the petitioner stood approved on and from 1st September 2006 on the vacancy that was created from the said date. Prior thereto, the petitioner was serving in an unsanctioned post. Stop. Learned advocate for the petitioner is directed to revert with better instruction as to whether direction for grant of notional benefit can be issued where an employee was serving in an unsanctioned post. Can you come back within 2 weeks?
Within 2 weeks, madam.
23rd of February.
Yes, madam.
Affidavit of service filed in court is taken on record.
Get to know.
I am for the petition. I am for the commission. Okay.
Before Lordship, the petitioner was appointed
Page 14, my lord.
as assistant teacher of mathematics. She was posted at Dubasol Junior High School, Paschim Medinipur. The petitioner husband have made a representation on Ususi portal, my lord. And paragraph 5, I have elaborated mentioned. But the husband of the petitioner is a lady, my lord. Husband of the petitioner is now working under KMDA. The distance from this school, Calcutta to the school concerned is 250 kilometers in one way.
Single teacher fresh
Right.
application to be made.
But
The petitioner participated.
Where is Dr. Patro?
Lord,
He was here just now. See, he must be there. Has any report been served upon?
Sabha, I have also, my lord, the exception I filed, my lord.
What is the stand in the report?
Stand is the report, my lord, the petitioner successfully empaneled. My lord, the serial number 2 empanel candidate.
How many
And
vacancies? How many vacancies?
Vacancies, my lord, they have stated in the affidavit, my lord, they has successfully empaneled, and my lord, the name was sent to the board. Board, my lord, withheld the appointment. There is no.
Hey, who's for the board?
My lord, one thing is, my lord, the board is not the party, and leave to, my lord, the liberty to add it. Because, my lord, I think, my lord, the name was not recommended. But, my lord, the standpoint of the School Service Commission, the name was recommended to the board.
Has the board annexed any document to show that her name was recommended?
Well, they have stated in the affidavit, my lord.
They have stated.
Yes. Paragraph, my lord, the.
So you want leave to add the board?
Yes, yes. Yeah, otherwise, my lord, we don't know why the approval letter was not issued in favor of the petitioner. But there is no dispute. Is the impanel candidate, second impanel candidate, my lord, and my lord, the name was sent to the board for the appointment. But the board withheld the appointment, not issue the approval letter to the petitioner. That is the point, my lord.
Is your report ready? Because you've served copy.
Yes, then it must be ready, but I've overlooked the matter, so the brief hasn't come.
On the prayer of the learned advocate representing the petitioner.
Yes.
To add the West Bengal Board of Secondary Education as party respondent in the instant writ petition, comma, leave is granted to the petitioner to add the board as party respondent and serve copy of the writ petition upon the added respondent. Stop. Let a copy of the report prepared by the West Bengal School Service Commission be also forwarded to the to the board for perusal. Stop. Learned advocate representing the board shall come ready with written instruction on the adjourned date, 2nd March.
Exception file.
See, the report is not here. Why keep the exception? Let the report come, then I'll take the exception.
Get.
79 for the petition. This is higher scale of pay. The lordship already just back to that I could come.
Any rejection given?
That is
No, my lord.
yes, that
What
has
has been rejected
that has
is
been rejected.
37.
Item 7.
Page 37 actually relegated to the commissioner for my lord proper instruction because earlier he was আচ্ছা বলো 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 আমি তোমার পক্ষেই
Page 37 additional distinct schools refer the matter to the commissioner with the observation. And your lordship will second paragraph, as the prior permission for enhancement of qualification from the competent authority, either the distinct schools or the additional district schools was not taken. Your lordship just kindly turn to page 26.
Yes.
This is the MC Managing Committee resolution. last paragraph. Just may I read it? This is important. মাননীয় শিক্ষক শ্রী তুষার মাইতি মহাশয় একটি আবেদনপত্র পাঠ করা হয়। আবেদনপত্রে শ্রী মাইতি মহাশয় সভাকে জানান যে তিনি বিদ্যাসাগর বিশ্ববিদ্যালয়ের অধীনে এমএসসি কেমিস্ট্রি পার্ট 2 পড়াকালীন বিদ্যালয়ে যোগদান করেন। তবে বিদ্যালয়ে যোগদানকালে এমএসসি পার্ট 2 পঠন পাঠন শেষ হয়ে যায়। মানে entire the course was completed prior to joining. That is the exactly the covered by Adiluzzaman judgment.
যোগদান কালে, not that
No.
পূর্বে।
যোগদান কালে এমএসসি পার্ট 2 পঠন পাঠন শেষ হয়ে যায়।
হ্যাঁ।
Not only the examination was held after joining, course was completed. That is the I have supporting documents I have annexed only examination that was study leave was granted by the sanction by the board only for that period. Now that permission was not required from the he has taken from managing committee. Now the Utpal Kanti Karan the permission from the managing committee is sufficient. But in that case, the Adiluzzaman division bench judgment said that if the part of the course was who was studying prior to joining, no required for permission. This is the judgment I have annexed page 43. In this case, admittedly, he completed his course prior to joining. Now the examinations was held upon taking permission that has been approved by the board that I have annexed the board has sanctioned my study leave. So nothing permission is not required. Maybe he referred to the commissioner because of these reasons. Now the I 37 because he could not reject my prayer for her scale of pay.
But he was appointed, it appears from the, because page 20, he was appointed on 6/11/2007.
Come. The petitioner claims higher scale of pay. Stop. The case made out by the petitioner is that prior to joining service, his MSc course stood completed. However, the examination was yet to be held. Stop. During his service period, the petitioner obtained leave and participated in the and he appeared in the examination. Stop. The
board has sanctioned page 32.
The study leave taken by the petitioner to appear in the examination was sanctioned by the board. Stop. Paragraph. The prayer made by the petitioner for grant of higher scale of pay was forwarded by the Additional District Inspector of Schools, Secondary Education, Ghatal, to the Commissioner of School Education in June 2019. Stop. There is no reply till date. Stop. Learned advocate for the petitioner relies on the judgment delivered by the Honorable Division Bench of this court on 11th of February 2021 in MAT 825 of 2020, page 43. In support of the submission that the District Inspector of Schools ought to allow the prayer of the petitioner for grant of higher scale of pay as there is no requirement of obtaining prior permission, since the petitioner took admission and completed the postgraduate course prior to joining service. Stop. Paragraph. Reliance has also been placed on the judgment delivered by the Honorable Special Bench of this court in the matter of Utpal Kanti Karan. Or cost title or citation ta বসিয়ে দেবেন। ঠিক আছে? Paragraph. It has been submitted by the petitioner that the A prayer of the petitioner for grant of higher scale of pay ought to be allowed by the District Inspector of Schools. Paragraph. Learned advocate for the state respondents submits that the issue is pending consideration before the Commissioner of School Education. Paragraph. As it appears that in the from the documents annexed to the writ petition, it appears that the ADI forwarded the prayer of the petitioner for grant of higher scale of pay way back in June 2019. Stop. Till date, there is no response to the same. Stop. Accordingly, instead of directing the Commissioner of School Education to look into the matter, the court is inclined to dispose of the writ petition, directing the District Inspector of Schools to take a decision on the petitioner's prayer for grant of higher scale of pay, relying on the judicial precedents mentioned herein above. Stop. An opportunity of hearing shall be granted to the petitioner prior to passing a final decision in the matter. Stop. A decision shall be taken by the aforesaid respondent at the earliest, but positively within a period of 12 weeks from the date of communication of this order. A reasoned order shall be passed and communicated to the party, to the petitioner. Stop. If the petitioner's prayer is allowed, the necessary consequential steps shall be taken without any further delay. Service is taken under.
The decision will be taken by the DI.
Yes, DI.
No use sending it to the commissioner all over again. He has not taken any steps.
Actually, after that, my lord,
Matter was referred by the ADI.
Utpal Kanti Karan, my lord, came into my lord field, my lord.
Lord, I am for the petition. This is the third round of litigation. Upon recommendation, my lord, I joined the service in 2001. Then I approached this honorable court for master degree scale of pay that was not given.
Is the report ready?
Yes, my lord.
Please give.
My lord's
Then
judgment, my lord,
petition. Then, my lord, I again appeared and recommended in 2007, my lord, in my present school where I am now working. Now, my lord, I approached this court by way of earlier litigation, and this court passed an order. If your lordship kindly have a look, my lord, the order passed by this court, my lord, at page 37.
Yes.
My lord, may I place? The petitioner, my lord, from last paragraph, the grievance which has been ventilated by instituting the writ petition this court today on behalf of the petitioner is on joining the second school with effect from 16th October 2007, anomaly cropped up in fixation of pay of the petitioner. By this writ petition, I am praying protection of pay. And according to the petitioner, pay of the petitioner in the second school was not fixed in consideration of his past service, which he rendered in the first school with effect from 19th March 2001. It has been submitted on behalf of the petitioner that since there is no break in service and subsequently he has been substantially appointed in the post of assistant teacher on the recommendation of the School Service Commission, he is entitled to get the benefit of his past service which is rendered in the first school in fixing his pay at the time of commencement of his service in the second school. Mrs. Choitali Bhattacharya, learned senior government advocate representing the state respondent, submits that the petitioner initiated contempt proceedings on alleged violation of the order dated 14th August 2015 passed by the coordinate bench, and in the order dated 13th September 2019, the coordinate bench has recorded the submission of the learned advocate representing the alleged contemptor that petitioner was not seeking continuity of service.
The direction was passed upon the commissioner to take a decision on your.
Oh, my lord, kindly excuse me. My lord, kindly turn, my lord, page 33, 32.
39, second paragraph. It appears that the
Yes,
petitioner worked.
it
I have
appears
the
that the petitioner worked.
Get it.
My lord, it has been recorded that there is no
41.
break of service.
Order of the commissioner.
My lord, the fifth line. Now, my lord, kindly have a look the order of the commissioner.
I think, my lord, 42 bottom.
All the submission information and records are taken into consideration. It appears is so and so. The writ petitioner was appointed so and so, my lord. From 18,000 to it reduced to 15,000.
Where is the order passed in contempt?
My lord, I annex that, my lord.
My lord, it is, my lord, at page.
My lord, order.
Page, my lord, 34. A question of praying for continuation of service in this, the contempt proceeding does not arise. That has been recorded by this court. Page 32, last two paragraphs. Last but three line, my lord, from the page 35. Court is unable to accept that by order dated 14th April 2015, there was adjudication of curtailing scope of challenge. Be it noted that the order dated 14th August 2015 was passed on concession and on basis of earlier ruling by the division bench of this honorable court. Mr. Biswas relies on 269 so and so for demonstration that there is no difference in applicable scale of pay. Mr. De submits the order sheet of this contempt application bears record of submission made by applicant that he is not seeking continuity of service. Why should I, my lord, I am putting this question, why should I claim for continuous? My first writ petition was not granting of higher scale of pay. And the court recorded, my lord, court recorded that order dated 14th April 2015, there was
contempt. This is the order which the respondents are relying upon. 13th of September.
Yes, 13th September 2019. They relied upon this order.
This is being relied on. আচ্ছা একটু বলতে দাও আমাকে আচ্ছা তুমি বলেই আচ্ছা
তাহলে আমি বলছি
ঠিক আছে বলো স্যার জিজ্ঞেস করছে আমি বলে দিলাম
question of continuation doesn't arise when the court recorded there was no break in service. Why should I not come before this honorable court for praying continuation of service? Court directed to my lord dispose of on the basis of 269 914. Kindly have a look, my lord, this circular of the government. This was relied upon by the court.
But this is the his submission. On that basis, contempt was disposed of, and this is the decision of the Commissioner of School Education. He will not pray for seeking continuity of service.
No, certainly not. I am paying.
This is a contempt
Where
application.
is the recording?
My
But
lord,
he will not seek the continuity in service. Where is that recording?
my lord, this is not the contempt application. I do not have the contempt application or all order passed in the contempt proceedings. My lord, this was relied by my lord. I think, my lord, there was something otherwise, my lord, you should not
pass any order over here.
Oh. Sorry,
just
see now. Sorry.
Kindly have a look. 941 circular, which the coordinate bench relied upon. Kindly see this circular.
269?
No, my lord, 941.
269 relied.
My lord, kindly have a look. What the court directed, page 40. The petitioner shall be at liberty to rely upon all relevant documents, including circular letter 1st August 2019. My lord, I have just handed over. My lord, this was the circular, my lord, issued by the principal secretary, Education Department. Kindly have a look. It is clear, my lord.
269? No, 914.
Kindly see, my lord, the matter regarding payment of salary and pay protection in service assistant teacher appointed afresh on recommendation of West Bengal School Service Commission undergraduate, postgraduate category has been under active consideration of the government for some time past. Now, after careful consideration of the matter, the governor has been pleased to say that the teachers having postgraduate degree and holding postgraduate category of post in within bracket, my lord, holding postgraduate scale, which I am holding, are eligible to apply for the post of so and so, provided they are within the prescribed age limit, subject to relaxation. So and so candidate on first day so and so are eligible to get last pay drawn protected. Last pay drawn, my lord, 18,720. Now it is reduced to 15,000. And treating me as a fresh service when the circular is absolutely standing in my favor.
Yes. What is your client doing?
My lord, only, my lord, that order is not lying with me, my lord. The undertaking or, my lord, submission recorded in the contempt proceedings is, my lord, this order was passed.
Kindly see the contempt
I have seen
order.
everything, my lord. Only the petitioner gave such undertaking or recording before the contempt proceedings. Accordingly, my lord, the Commissioner of School Education.
Where
has
is
this
the
order.
undertaking, my lord? I am putting this question
You
myself.
challenge that
Page
question. You
34.
could have,
Why should I?
you,
Why
if
should I?
anybody is agreeing contempt
No,
proceedings,
I am.
he
I
could have
cannot.
preferred an appeal also.
Wait. Your order, impugned order,
Yes,
page number 42,
my lord.
13th of September 2019 is
My lord.
recorded.
My lord.
Petitioner made a submission is not that he is not seeking continuity. Where is that recording? Show me from 13th of September 2019. Where is that recording?
Yes, 34, my lord. My lord, that, my lord is asking that, where is that recording? But then I have to use affidavit. Otherwise,
No, sir. You are not required to use an affidavit. The date of the order is there. You
yes,
can make out something in the affidavit which is not
but
there.
submission is being recorded in the contempt proceedings.
Not in air. Submission is recorded in the order sheet.
Yes.
The order sheet is annexed.
Yes, and
How can you input something over here?
Certainly, I am not, my lord, this is my respectful submission. I am not inputting. This is the basis of the commissioner order that this submission is being taken into consideration.
How can it be done? This is the query of the court. If something is not recorded in the court's order, the commissioner cannot take it and assume something.
But, my lord, I am putting question marks. If anybody is agree with any observation made in any proceeding, could have, my lord, file one review or modification application.
Who is
He
aggrieved?
is suffering with, my lord.
He is not aggrieved. It is you who is putting up
No,
things.
my lord, my understanding is
Your wrong understanding.
that may be, my lord. But this is the basis of the order passed by the, my lord, Commissioner of School Education.
That he is not seeking such any differences.
The memo relied upon by the coordinate bench is absolutely in my favor. In both the school, I am getting higher scale of pay. There is, my lord, no dispute on that. But the pay protection has to be given.
Please come. Report filed by the
Commission of School Education. 16/5/20.
Where is the original?
My lord. All are black. Oh, sorry, my lord. Sorry, my lord.
Report filed by the Commissioner of School Education signed on 16th of May 2024. In court today, we retain with the records. The petitioners' prayer for pay protection stood rejected by the Commissioner, relying on Commissioner with the observation that the petitioner made submission. Now, with the observation that the petitioner made submission before the court as recorded in the order dated 13th September 2019 in WPCRC number 207W of 2017 that the petitioner would not seek continuity of service. Stop. The order dated 13th September 2019 is annexed to the writ petition and the report filed by the Commissioner. Stop. It appears that the issue of continuity of service was not a matter to be adjudicated by the court in the contempt proceeding. Stop. The court in the order dated 13th September 2019 clearly recorded that any difference in scale of pay drawn by subsequently applying and being commended for fresh appointment on scale of pay would be a substantial cause that cannot be decided in the contempt proceeding. Stop. The petitioner was granted leave to obtain further relief on the said substantial cause, if so advised. Stop. The petitioner filed fresh writ petition seeking pay protection. Stop. The Honorable Court, vide order dated 14th December 2022 in WPA 4057 of 2022, passed order directing the Commissioner to take a decision on the entitlement of the petitioner to get the benefit of pay protection relying on the circular dated 1st August 2019 being number 914. The Commissioner, in compliance paragraph of the aforesaid order, passed the impugned order
7 June 2023.
on 7th June 2023 by holding that without continuity of past service, no protection of pay can be granted. Stop. The Commissioner held that The prayer of the petitioner is barred by the principle of estoppel, as the petitioner himself relinquished his claim of continuity of service. Stop paragraph. On hearing the submission made on behalf of both the parties and on perusal of the documents placed before the court, it appears that the commissioner misread the order passed by the court and misdirected himself in passing the impugned order. Stop. It does not appear that the petitioner ever relinquished his right for continuity in service. Stop. In fact, it appears that the service of the petitioner from one school to the other was continuous without even a day's break. Stop. The order of the Principal Secretary, School Education Department, dated 1st August 2019, clearly permits pay protection to such in-service assistant teachers appointed afresh on recommendation of the West Bengal Central School Service Commission. Stop. There is no reason as to why the benefit of the order dated 1st August 2019 according pay protection will not be made applicable in favor of the petitioner. Stop paragraph. The paragraph, in view of the above, the instant writ petition stands disposed of by setting aside the impugned order, impugned office memorandum dated 7th June 2023. Stop. The instant writ petition stands disposed of by remanding the matter back to the commissioner for a fresh decision upon applying the order of the Principal Secretary, School Education Department, dated 1st August 2019. Stop. An opportunity of hearing shall be provided to the petitioner. Once again. Stop. A decision shall be taken at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. If the prayer of the petitioner is allowed, comma, necessary consequential steps shall be taken without any further delay.
My lord, again, matter remanded back again, my lord, I have to,
Yes.
my lord, kindly
doing.
appreciate this position. When the circular is
Appreciate
kind, my lord, is supporting my claim.
A reporter will be written with the records.
My lord, I appear for the petitioner. This is a matter of 2023. I tried serving notice on the learned advocate who has been allotted the brief, Mr. Supriya Chattopadhyay. However, his junior informed us that he's the junior who was allotted, he no longer is a part of the panel, present panel, and the senior refused to accept the, possibly there is some medical emergency.
Please come. None appears on behalf of the state respondent. Stop. Where is your service, please?
My lord, this is my affidavit, original affidavit of service.
Let fresh service be effected. Let notice be served in the office of the government pleader. Released on 2nd of March.
Deeply obliged, my lord.
My lord, I'm for the petitioner, my lord. My lord, petitioner playing for interest of area pension, my lord. Earlier occasion moved this up, my lord, page.
Not area pension, area salary.
Area salary, my lord, sorry. My lord, page 58, my lord. 58, my lord.
For so many years,
Yes,
from 86 to 2010.
yes, my lord. Area salary is paid, but interest has not be paid, my lord. I moved this application, Honorable High Court, my lord.
Where is your report? Please give.
No, my lord, I could not, my lord, kindly grant me 1 week time to obtain the report.
Retire on 2010, my lord.
Yes, my lord, an order was passed on page 71, refusing interest.
An order was passed by this court on 1st of May
Yes, my lord.
2024. The report has
Yes, my
not been
lord,
filed.
since after long date is coming.
Then
my lord,
let the DI pay some costs.
my lord, only 1 week, my lord.
No, no.
My lord, kindly
sir.
give me 1 week. My lord, perhaps it was not communicated to the DI, my lord, that's why. my lord.
Then the learned advocate who was there, I can see your name recorded.
Yeah, my lord, I know, my lord.
Then?
Court
My lord,
engaged,
personally
since nobody appeared, the court engaged me, my lord.
Whatever, I do not know. If you
Yes.
say you won't appear, you won't appear. It's
No, my lord, I am
submitted
appearing as per direction of the Honorable Court, I am appearing. My lord, kindly grant me only 1 week time, let it be on next week, my lord, I will come.
Matter, the
But I will
Honorable
come with the
Justice
report,
has
my lord.
passed this one on a page. My lord, kindly see that.
I will come with the report, my lord.
Page 75 and 76, my lord, kindly see.
Page 72, I can see an order of the DI.
My lord.
He claimed compound interest for delayed payment from 86 to 19 at the rate of 14% without knowing the provision of the government. But this he paid interest for the period from 1 to such and such. There is no provision for allowing interest on delayed payment of the area salary. When did you receive the money?
2019 perhaps.
2019.
And you retired in 2010?
Yes, madam.
31st of March
Yes,
2010?
4 times I filed the writ application, madam. Yes, madam. Retired on 31st March 2010, madam. Petitioner is seriously ill, my lord. Yes.
Please come. The petitioner is a retired teacher. Aged about 75 years. Stop. He retired from service on 31st of March 2010. Stop. His salary for the period 1st January 1986 to 31st March 2010 was paid in the year 2019.
Yes, area salary.
Area salary
Yes.
was paid in the year
Yes.
2019.
As per direction of the Honorable Court, madam. Yes.
Approval was granted after his retirement.
Areas of salary. কি বললাম? His 2019. Stop. He prays for grant of interest on account of delayed payment of his salary. Stop. The court video order dated 1st May 2024 directed the DI Secondary Education District Hooghly to file a report on the claim of the petitioner. Stop. No report is forthcoming till date. Stop. Learned advocate for the petitioner submits upon instruction that the petitioner is seriously ill and he requires immediate finance for his treatment. Stop paragraph. The court is of the opinion that the employer ought to have paid the employee the salary immediately, a salary on time. Stop. The petitioner was paid salary long after he retired from service, and that too upon order being passed by the court. Stop. Next.
But his service was approved in the year 2015 only, my lord. After his retirement, because there is this. Yes, 2015.
রিটায়ার করেছে কে বলেছে ওই এটাকে এরিয়ারটাকেও স্যাংশন করেছে এরিয়ার স্যালারিটাকে
2015
এরিয়ারটা আমি দেখুন এই দেখুন দেখবেন আচ্ছা আচ্ছা দেখিয়ে দিচ্ছি এই যে দাঁড়া এই যে এই যে পেজ 41 পেজ 41 দেখেন 41 এই যে এই দেখুন 15 12 এই যে অ্যাপ্রুভ করে 23 টাকা এই যে এরিয়া
Area salary. Yes. Area salary was approved 2015. কিন্তু এখানে সেটা তা বলেন ভুল আমি সেটা দেখেই বলছি
The District Inspector of Schools, Secondary Education, Hooghly, is directed to calculate the interest on account of delay in releasing the salary to the petitioner. কি বললাম? Is directed to calculate petitioner interest আগে simple interest at the rate of 7% per annum on and from the same fell due till the date of actual payment. Stop. The amount payable to the petitioner shall be placed before this court on the adjourned date. Released on 23rd of February 2026. Next.
নাম লিখে দিয়ে দিচ্ছি
21
নাম দিয়ে দিন নাম দিয়ে দিন
This is also, if your lordship kindly have a look to last 2 pages, my 2 representations.
Who's for the state?
My lord, I am on behalf of my senior, Mr. Vimal Kumar Shahi. He'll be appearing
online.
Online.
Yes.
Yes. Please.
Let the
I am appearing on behalf of state, my lord.
Yes.
That I made 2 representations, page 31 and 32.
Yes.
To the District Inspector of Schools regarding non-payment of interest on my deposit of GPF account to the ADI office. If your lordship can have a look to page 29, by this office memorandum of 23rd of August 2021, the ADI has accepted that per the petitioners 14,43,368 is being deposited to this office because I had been transferred from one school to other and the PF has been transferred from the earlier school to the present school. Now, the present school where I am working at present, they have not received the pension PF amount within that time. So, I made two representations to the AI of schools of the PF section, page 30, page 31, then 32 and 33. Only if your lordship kindly direct the DI to consider the case, because page 25 is also a letter to the AI PF section where page 25, got it? Yes.
Your
Where
PF was not transferred from one school to the other.
no, PF has been transferred from one school to the ADI office.
ADI office, yes. Delayed point of time.
Yes. Now, the delay which caused the interest that has not been paid to me. But kindly have a look to page 25 once. Transfer of GPF amount from old school Nidisha so to the new school Shaithia Jogesh.
Submission before your lordship, my lord. My lord, petitioner was paid amounting to rupees 14,43,368 rupees, including 6-month interest from the office of the AI of school by memo number 49 dated 23rd August 2021, my lord.
Yes. Then?
Amount is already paid, my lord.
Yes, I'm paying for interest.
Including 6-month interest, I have paid, my lord.
Interest has been paid. It is a submission.
Let him file a report to this effect. By making oral submission.
14,043,306.
Well, it's not an oral submission. I have a instruction, but it's not eligible. That's why I am not submitting before your lordship. Allow me 3 working days time. I will hand over to before your lordship the instruction which I have.
The petitioner claims for interest on the provident fund amount that was paid by her. Stop paragraph. Learned advocate for the state respondent submits upon instruction that the amount paid to the petitioner includes the interest. Stop. Letter report with supporting documents and the breakup of calculation showing payment of interest.
My lord.
Prepared and circulated by 20th of February. Released the matter on 5th of March 2026.
Grateful.
Deeply obliged, my lord.
Grateful, Your Lordship.
Who's for the state?
Well, I have this notice দেওয়া আছে তো হ্যাঁ yes yes Gaurav Das.
Where is Mr. Das? Call him. Tell somebody to call him. What is the matter about?
This is higher scale of pay. No decision has been taken.
No decision taken.
Or this is a case where part 1 examination was held prior to joining by the Adiluzzaman. Exactly, well, as item number, but the no decision, there is no forwarding letter to the DI.
Please come.
17.
The prayer of the petitioner seeking higher scale of pay on account of enhancing his educational qualification is pending consideration. Where is the application?
That application forwarding letter page 54.
Is pending consideration.
She completed MSc part 1 examination.
Before the
at the time of
Additional District Inspector of Schools, Secondary Education, Kontai, Purva Medinipur. Stop. The petitioner submits that he, she. Is it he or she?
She.
Actually, that she completed her part 1 examination prior to joining service and accordingly there was no scope on her part to obtain prior permission for enhancing her educational qualification. Stop. Next. Reliance has been placed on the judgment delivered by the Honorable Division Bench of this court on 11th February 2021 in page 72, Mat 825 of 2020. Yes, yes. Reliance has also been placed on the judgment delivered by the special bench of this court in the matter of Tarok Korun. Citation telegram. Stop. As it appears that the prayer of the petitioner is pending consideration. Accordingly, the instant writ petition stands disposed of by directing the District Inspector of Schools. Will it be the ADI?
My lord, direct the AC Purva Midnapur. ADI, my lord, the
DI.
under the DI. ADI under the DI. DI Purva Midnapur. Thank you. DI.
Yes, DI. AC Purva Mendipur. To take a decision on the petitioner's prayer seeking higher scale of pay after giving opportunity of hearing to the petitioner for production of relevant documents in her favor. Stop. The ratio laid down by the court shall be looked into by the DI prior to passing a final order in the matter. Stop. A decision shall be taken at the earliest but positively within a period of 12 weeks from the date of communication of this order. If the prayer of the petitioner is allowed, the necessary consequential steps shall be taken without any further delay. Stop. Learned advocate for the petitioner is directed to forward the subject representation. Subject na. The representation seeking consideration along with all supporting documents to the DI at the time of communicating the order of the court. Disposed service is taken on record. Record appearance of state.
23. I appear for the petitioner. But here, my lord, I ফাইলটা জশপকে দিয়েছেন? ফাইলটা জশপকে দিয়েছেন?
Yes.
I was appointed and approved in a school at Bethuadahori, Nodia. I got transfer, page 17, from Nodia to Shami Vivekananda High School, Shamnagar, Jagodal. Now, when I went to join there, page 18, on 10th of June 2022, the teacher in charge, I am a teacher of work education. Now, the teacher in charge is writing that in the institution an assistant teacher against his post of work education, we are very sorry to say that there is no such vacancy in our institution, as it has been filled up by one teacher of physical education since 2011. In this regard, we would hope your further proceeding to confirm your country. Now the difficulty is, I am a teacher, I have been appointed as a work education teacher in 2014. So on my request, the transfer order was made. The school has said that
No, I have understood. Now, where are you? In your old school,
old school, Bethuadahori. I cannot go and join there.
All right. Commission, fresh recommendation is to be given.
My lord, kindly see paragraph 5. My learned friend writes, the petitioner subject to the petitioner without getting any weight had approached the commission for her recommendation. This happens when there is a wrong recommendation. Whether this is wrong or not, this is not very
It cannot be understood from the letter of the school because the physical education cannot fill up the post of a work education. So
I fail to understand.
this letter meant I don't know, but what is troubling me is the prayer.
What is the prayer?
In the abandonment, my learned friend says that I want to be re-recommended, and in the prayer he says, do not re-recommend. Can you see the prayer at page 11?
Now, what I have said in paragraph 5, but I have narrated the fact that the petitioner submits that the petitioner, without getting any way, had approached the commission for her re-recommendation. In reply to such, the petitioner submits that the respondent commission had generated an ID being general transfer number, proposal number, so and so, but no
So it was under process at that point of time.
It is not concluded.
Yes, but then
But no intimation had been given to the petitioner by cancelling the first recommendation of Swami Vivekananda School and shortlist a second application. So, what is my wrong?
No, but what is how does the prayer?
If you do not,
have you taken instruction?
No,
It's better you take instruction if there is a confusion in your mind with regard to the re-recommendation proposal. Then it's better you take instruction and come back. So then you can say that the petition is recommended to ABC school. The court will record it and pass order. Or you can bring an order of.
I can take, but possibly since it's a 2022 transfer order.
Yes.
It's better that the petitioner make a fresh application.
No, but then this is your recommendation. There is an error with the recommendation.
No, the recommendation is purely on the basis of the vacancies which are given to us by the education department.
Maybe,
Yeah.
but then petitioner is no way responsible.
No, not for that part. But again, what is the school trying to say? That is also not very clear.
Check up.
Very well,
Come
let
back
me
with a
come back.
report.
Let me come back.
Because in usual course, the court passes order for re-recommendation.
Yes.
And several matters orders have been passed.
Some problem with regard to the vacancy, we always allow the recommendation. That is
Yes.
the issue.
But if something is
but if your lordship can direct the
there in
school
your
to
mind.
allow me to join, because the post is being occupied by a teacher of physical education,
and how can this be done? Work education.
and the teacher in charge is writing this letter.
And there is no similarity between the two posts.
Absolutely
and the
no.
requirements are different. They're
Right,
recruited
right,
different.
right. I do not know. Please come. The petitioner, though recommended to a school by the commission on 31st of May 2022, was unable to join there as the teacher in charge of the recommended school intimated her that there is no vacancy. Stop paragraph. The petitioner seeks re-recommendation. Stop. Learned advocate representing the commission is directed to revert with written instruction. Fortnight will be all right with you? 23rd.
23rd February.
Yes.
Grateful.
Keep the black.
I was very upset. What should I do?
I'm for the state respondent, my lord.
So this is also higher scale of pay. My lord, the petitioner's pair has been rejected by the authority, page 47. In fact, my
But
lord,
in the last occasion,
he did not take permission from the DI of schools. My lord, in this case, he could not take permission because it is a minority institutions. My lord, his approval was kept pending before the DI when he was continuing, my lord, the study course. Your lordship will find, my lord, the page 27.
There was a direction for filing of a report. Let me see.
Report already rejected.
না, বিশ্বজিৎ বাসুর কোর্টে দিয়েছিল।
Give a copy to him.
Yes.
This is exactly which has been, my lord, the stated in the impugn order. That
Same thing has been
same thing has
stated.
been stated. Same thing. The two government order has been relied. 548, 593. This is both the, my lord, the government orders are not applicable. 548, my lord, that has been dealt with by the Honorable Division Bench in Akhtar Hussain Chowdhury. It is the, my lord, the not related to higher scale of pay. And 593, my lord, the to take permission from the school authority, from the competent authority. my lord, your lordship will find page 27.
No meeting was held by the school also.
That I will produce, page 27. My lord, your lordship will find, my lord, the page.
And the DI was communicated after all the processes, my lord.
Page 27, my lord, he
On
joined,
7th of
my lord,
October
on 1st July 2011. Your lordship got it? Page
20.
27.
Yes.
Approval was accorded 30th April 2012 at the top, my lord, the right hand side. So before 30th April 2012, my lord, he applied, and my lord, he was studying through distance education mode from the Vidyasagar University. And my lord, he took admission, page 30, 1st October 2011, page 30. When the, my lord, until and unless his service has been approved by the DI, my lord, DI cannot, my lord, school also, my lord, did not approach, my lord, the DI to take permission.
School
And
did not
ultimately,
have not
and my lord,
already meeting also,
ultimately 2013, he, my lord, completed his course. Regarding permission, my lord, that is, your lordship will
the
find
DI was informed in
page
15.
page 4, annexure 4, page 28. He my lord, approached for, my lord, he obtained permission. School has granted permission. At that time, my lord, his service was not approved. He was an unapproved staff. So there is no question to take.
Where is the school's decision?
This is the, my lord, your
Page
lordship kindly see.
28.
Page 29. So we are pleased to inform you, you are hereby granted necessary permission to apply for studying MSc in course, chemistry. This is the, my lord, the decision has been, my lord, the teacher in charge granted permission. Whether the MC resolution or not, that I do not know. Only these reasons. And on another thing, my lord, very important, you will also kindly see, page 51. My lord, he is a teacher of higher secondary section. This has been communicated in 2023. Now, as per the Amendment Act, I was appointed an assistant teacher in higher secondary section. So, as per amendment, I am entitled. That has been now amended. The DI has issued a corrigendum that yes, you are the teacher of higher secondary section. That is the mistake in the approval letter. So, I am entitled, my lord, the amendment, page 52, I have annexed. That is clearly stated. Who were appointed, my lord, in higher secondary section is entitled. Apart from the ground of prior permission.
Which one? Page 52?
Page 51, this is the corrigendum.
Higher secondary
Page
section.
52, this is the amendment.
Yes.
Amendment, you will also kindly see. Section 14 has been amended.
Yes.
Subsection 3.
Every teacher.
In subsection 2, every teacher of a school shall, if appointed in the post of graduate teacher, be entitled to the next page. So kindly see, this is next page. 3. Page 53. Every teacher appointed for classes 11 and 12 shall be entitled to draw pay mean for postgraduate qualification. So I was appointed initially in higher secondary section. That was not mentioned. That is why corrigendum has been issued by the DI. DI himself issued. Actually, I am an assistant teacher of higher secondary section.
And shall not be entitled to claim any additional increment or for any qualification other than the minimum qualification
specified for such post. Post mean for postgraduate qualification.
11-12 is postgraduate
Yes,
qualification.
that is obviously. Now after the amendment, I am entitled. That is not the dispute, my lord. They have also, my lord, issued this. Apart from the prior permission, I could not take permission. That is the, my lord, because my approval, this is the minority institution.
What is the judgment that you've annexed over here?
No, I have.
In this matter, have you annexed any judgment?
No. In this matter, I have not annexed any judgment. This is the, my lord, regarding prior permission, regarding government order of 548, mentioned, my lord, by the DI. That is the, my lord, Akhtar Hossain Chowdhury. This is clearly, division means clearly stated that. Second page, that government order has been quoted. Now the third page, the aforesaid circular relates to recognition of correspondence course conducted by the different universities of India and not relating to grant of any benefit for improving the academic qualification through correspondence. This is the judgment, already judgment, and others, my lord, the order has been passed relying that judgment. You also can see another judgment, my lord, passed by the coordinate bench relying Akhtar Hussain Chowdhury, paragraph 10. পার্থ পুটিং দেখো, পার্থ পুটিং দিয়ে কোনো জানি আছে। সবাই করেছিল।
593, where has it been considered?
593, this is, my lord, I have annexed. 93 annex করেছি। 593, my lord, the honorable larger bench in Utkal Kanti Karan, my lord, held that 593 has no existence. This is 1595, 26 December 2005. Permission from the competent authority, that is managing committee, is sufficient.
Not the school authority sought any permission from the district.
Yes.
Lordship will kindly see the report. Neither the school nor the petitioner thought it necessary to bring the matter before the managing committee or to inform the DI?
The managing committee, it is.
No resolution was taken by the managing committee. Teacher in charge allowed him. Let them show any document that managing committee permission was taken from the managing committee prior to joining the course. It is between the teacher in charge and the petitioner.
Yes.
And after he obtained the degree, then only the school authority informed the office of the DI about his obtaining and claiming higher pay scale without taking any prior permission or anything. As such, he is not entitled to the higher pay. Let the school come and say that yes, managing committee took a resolution prior to his obtaining that higher degree.
Is the
No
school-
resolution was taken.
Is the school a party?
Yes, my lord. School is a party. 5 and 6. No, 4 and 5.
September.
Did you serve the school? Upgradation notice possibly has not been served. Ajay, please come. The petitioner's prayer for higher scale of pay stood rejected on the ground that prior permission was not taken before enhancing the educational qualification. Stop. Next. None represents this school. Stop. Let notice be served upon this school, intimating that the matter will appear in the list on 2nd March. Stop. The District Inspector of Schools, Secondary Education, Kolkata shall also intimate the school regarding fixing of hearing of the instant writ petition on 2nd of March 2026.
Lakshmi will kindly record that.
The report filed by the District Inspector of Schools, Secondary Education, Kolkata, signed on 16th of May 2024, be written with the records.
Hmm. 25 I am for the petition. This is with regard to non-payment of the arrears salary of the month of January and February of the year 2020. The petitioner, along with granting of 10 years service benefit of the petitioner. Now the arrears salary has been credited as on November 2025.
20
Due paid
due
on
paid in
November
25.
Today I am praying for some interest on this delayed payment, Your Lordship.
And what about the 10 years increment?
10 years service increment, Your Lordship, the petitioner states that he has not been granted, but there is some dilemma with that.
So you are not pressing.
We are not pressing that.
All right. Yes.
My lord, I have not received, my lord, any instruction, my lord.
Why?
DI, my lord, transfer today, the new DI will join, my lord. District Inspector of Howrah, my lord, will join today, my lord.
No, but the writ petition was filed in 24.
My lord, before that,
From
my lord,
24 you did not.
not come, my lord. Kindly give me 1 week time, my lord. Actually, my lord, kindly
Please
come.
come.
To my lord,
The petitioner
actually, school will
seek
send the, my lord,
grant of 10 years benefit and interest on account of delayed payment of his salary. Stop. It has been submitted that the salary for the
January, February 2020.
months of January and February. But your prayer is for pay revision for the months of January and February.
my lord, school has not, my lord,
And
sent
salary in the month of February.
Payment and calculation, my lord.
Finally comes to prayer B. Your
Without receive any instruction, please don't make any submission. All right.
Prayer B, Your Lordship, this was a
Prayer B, yes.
arrears
This
of
was
pay
the
revision
arrears of
because
pay
the salary was
revision.
revised as per ROPA 2019. It was
Right.
given effect from 2020.
So, is it the pay or the arrears of pay?
Arrears of pay.
You got the salary
I got
according to the prior scale.
partly. January in part I had received, your lordship, and February the whole salary was due.
It has been submitted that part salary for the month of January 2020 and the entire salary for the month of February 2020 was released in November 2025. Stop. The petitioner seeks interest on account of such delayed payment of salary. Stop. The petitioner, however, for the time being, does not press the prayer for grant of 10 years service benefit. Stop paragraph. Learned advocate representing the state respondents is not aware as to why the full salary for the month of January 2020 and the salary for the month of February 2020 was not paid on time. Stop paragraph. As admittedly there has been delay in making payment of the salary, accordingly, the district inspector of schools is directed to grant simple interest on account of delayed payment of the salary. District Inspector of Schools, Secondary Education, Howrah, 4. Delayed payment, simple interest at the rate of 5%. It has a 2020 te. Make it 7%. Per annum, calculated on and from the date it fell due till the date of actual payment. Stop. The interest shall be disbursed positively by 29th of May 2026. Disposed.
I appear for the petition. But I am seeking transfer, my lord. I am a physically challenged person. I have 60% disability. Well, in 2014, I was transferred to.
Show me your status, transfer application status.
But I made that application in 2021. My lord, this is appearing at page 26. And 27, my lord, is the status. 27, 28, 27, my lord, the status is showing. 26, it was forwarded to the head of the institution.
Then,
thereafter, nothing has happened. After this, social portal was kept in abeyance for a couple of years.
That is from September 22. It was kept in abeyance.
Kept in abeyance. My application was never considered. I made representations at pages 30. That was in 2021. 30 and 31.
Let me hear the commission once. Any idea?
It is not, my lord, apparent from this.
Right, page 26. Nothing can be understood.
My lord, I have seen, my lord, page 34.
Yes.
My lord, he had made one application before the district inspector of schools, offline application.
Oh, this is in 2024. But prior to that, in page 30, 31, my application is of 12th of September 2021.
Well, in this matter, my lord, kindly turn to page
Employee
31.
code application number has been given.
Page 31.
No,
No, instruction.
31.
31, right hand column. DI forwarded to WBCSSC on 12th of September 2021. My lord, I have to take instruction whether DI at all, my lord, forwarded or not. My lord. Kindly fix them at any other day, my lord, so that I can take them.
Page 31 at the bottom left.
My lord,
What is
top of
this?
the list, right?
Look at the bottom left.
Received West Bengal Schools Service Commission.
Yes.
My lord, this is the representation petitioner made before the advisor West Bengal School Service Commission.
Whether the application was forwarded or not, nobody knows.
Nobody knows, my lord.
This is in
But I was
21.
told, my lord, there is specific government that application was forwarded.
Maybe.
Ah.
Please come. Self-medical ground.
मतलब physically handicapped. PWD.
PWD. Persons with disability. But disability.
PWD candidate on self-medical ground.
No, my lord, another. मतलब there
Special
are-
ground.
Yes, my lord. 4A is self-medical, 4B is PWD.
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 All right. PWD category. ठीक है sir. Applied in 2021. No steps taken. School, but then fresh application is to be made. Considerable time has elapsed. Make a fresh application offline. The court is granting leave.
But it petition disposed of.
Yes, yes.
Disposed of.
No.
But I am appearing for the statement.
Yes.
I'm appearing on behalf of the
The petitioner is going to approve group D staff, applied for the transfer, my lord. The transfer order was passed in favor of the petitioners. My lord, the petitioner went to the join in the new school, my lord, but there is no vacancy in that school.
Where is the recommendation?
My lord.
Recommendation of the commission?
Yes, my lord.
मतलब recommendation is in the page, my lord.
17.
17.
Page 17.
You want re-recommendation?
मतलब then subsequently,
Again, thereafter, my lord, made again my
Page 21.
representation so that, my lord, the new school will be granted in favor of the petitioner. Page 35, my lord.
Non-availability, then my lord makes a representation, my lord page 35.
That means you seek re-recommendation.
Yes.
Please come. The petitioner seeks re-recommendation for transfer. Stop. He was transferred to a school by the commission in March 2022, but the petitioner could not join the recommended school because of non-availability of matching vacancy. Stop. The petitioner applied for re-recommendation but the same is pending consideration till date. Stop. As it appears that the petitioner's application seeking transfer was allowed and he was recommended to a school but could not join the same for no fault on his part, accordingly, the instant writ petition stands disposed of by directing the commission to re-recommend the petitioner to a school with matching vacancy. Stop. A decision shall be taken by the commission at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Writ petition disposed.
Get. Or affidavit, sir.
Salviston Yenevan.
Mother State.
An affidavit taking exception to the report, but I have twofold prayer before your lordship. Firstly, my lord,
There is a report.
my lord, I had twofold prayer before your lordship. Firstly, my lord, whether I should be getting the approval from the date of upgradation or recognition of the school or not as an organizer teacher, the first issue. Second issue, I had a deficit of, because of the appointment belatedly done, I had a deficit of 2 months. 6 months can be condoned. I have 8 months deficit for the purpose of getting pension. So my prayer before your lordship, at least, my lord, so far as the pension part is concerned, that is undisputed. Judgment of Justice Tapobrata Chakraborty, my lord, has been
Show me your date of approval.
my lord, I am showing you.
Page 10.
My lordship will take it.
26th of October 2016.
2016 given, with effect from 26th of October 2016.
Are you retired on?
My retirement is at to 30th of April 2026. 30th of April 2026. Therefore,
8 months short. This is your only prayer.
this is the first prayer. I have twofold prayer, I told you, Lord.
And then-
Secondly, my Lord, so far as my original approval part is concerned, Lord, you may kindly look at page 10. That was the order of the district inspector of schools. My Lord, an order passed in terms of the Honorable Justice Shahidullah Munshi, accordingly they have decided. In the issue of approval of appointment in favor of Sanjoy Kumar Guho, headmaster and president produced the original appointment letter. Kindly, my Lord, mark it, my Lord, subject to, my Lord, what false. Copy of managing committee resolution, DLIT report and other documents. So DLIT he has sent. In compliance with the order passed by his lordship, keeping in mind the law point and the verifying the all documents and the representation, it is observed that there was sanctioned vacant post of assistant teacher in the school. President, managing committee and the headmaster said Sanjoy Guho is working as an organizer teacher from 1991 and recognized and recorded by the DLIT team. As such, approval is granted from 2016. Coming belated to a lordship, my lord, whether your lordship will accept this or not, my lord, a rule speak of that from the date of recognition, I should get it. That your lordship will get it at page 12. That
Please do not make any submission. This order was passed in 2016, right? In the year 2024, just prior to your retirement, if you come and say that give me the benefit from the date the school got recognized, the court will not accept.
1993 onwards, law.
You should have come earlier. And you did come earlier in 2016. But thereafter, you didn't challenge it.
Before the Honorable Justice Munshi, my lord,
Whoever, you didn't challenge
that was for getting approval. And approval accordingly granted.
So you should have challenged it in 2016 itself.
I know, I told you, Lord.
Yeah, I understand. It's better you get the pensionable service benefit and
yes, my
be
lord.
happy with that.
I should restrict my prayer to that.
Right.
This judgment was.
No, my lord, there is no prayer.
No, I said from 1993 you give it. Now in paragraph, my lord, I have said that I will not get pension. My lord, in my writ petition, if the
Prayer, my lord, there is nothing. Prayer A and prayer B.
My averment at paragraph 7, I have said, paragraph 7 and 8. If the benefit not given, at least notionally, I may not get the pension. So at least that protection may be given, my lord, I am retiring.
This is the organization teacher. Where is the shortfall in service consideration? Is it mentioned over here?
No, my lord, that time it was not there. That time my approval was not there.
He may approach to the concerned authority for.
Right now, your prayer is for condoning your shortfall in your service period.
Now I am praying this.
Now you are praying this. Relying that, show me the judgment.
Judgment I have given, madam. There was a shortfall. It goes to BR's case. The organizer teacher period has been is to be taken into account. That has been held by.
The concerned authority to that effect.
কোর্টে এসেছি যখন আর authority কে আছে above the court?
But the submission of the order impugn as a suffering information.
Paragraph 8, not you see. DLIT report also, madam, they say my name is featuring.
That I have seen, but you cannot challenge that now.
I am not asking for the payment for that. Only qualifying service may be treated, madam, so that I can get pension. 2 months deficit, madam. And as an organizer teacher, madam, I have been given appointment. That has been admitted. Authority said 1991 onwards I am working. Condone the deficiency of 1 year, 2 months. Paragraph 12. এখানটা জমা দিয়ে দিয়েছি আমরা। My appointment details have been given, Malad, in the affidavit taking exception to the report. 91 onwards, I am working, Malad, that is also a document annexed to the petition.
Please come. The petitioner is aggrieved by the order dated 22nd December 2016, passed by the District Inspector of Schools, Secondary Education, Uttar Dinajpur, in according approval of appointment with effect from 26th October 2016. Stop. Paragraph. Specific case of the petitioner is that he was working as an organizing teacher from 1991, and his name features in the report filed by the district level inspection team. Step. The petitioner is due to retire from service on 30th of April 2026. He submits that if notional benefit is not granted to the petitioner on and from the date of recognition of this school, then he will be deprived of his pensionary benefit despite serving the school for such a long period of time. Stop. Paragraph. Prayer has been made to set aside the impugned order. To set aside the date from which the service of the petitioner stood approved, and to direct the authority to accord approval to his service on and from the date of recognition of this school. Stop. Paragraph. The prayer of the petitioner has been opposed by the respondent state by filing a report. Stop.
Page number 4, subpara Roman 2.
Approval of the petition was given by the DI. No, that is all right. But what about the DLIT report? His name is not there?
Yes.
Where is?
Said so in page 10.
No, that is the
perusal of the DLIT report have been approved.
That is the
Have you annexed? You have annexed in your DLIT report?
No,
I'm not honest.
No, he has annexed.
I have no document. I am the candidate. DI has said so. Page 10.
Original could not be, my lord. I asked the school. I have taken this point, my lord, after 8 years.
It is mentioned that the base
the original appointment letter, copy of the AMC resolution, and the DLIT report.
On the basis of the report of the headmaster and the documents annexed being SI would be evident the first recognition 1993. But there is nothing to state that the petitioners were appointed in 1991. I deny that the name of the petitioner was recorded in DLIT report.
Well, he is saying so in the affidavit paragraph 2.
Yes.
Say
That is the
contrary. No, it is
no,
your case.
no, this is not my case.
Report
This
in the
is
format which may be considered by the Honorable Court as follows. This should be considered. The petitioner joined the undersigned school with so and so in 4491. He is also saying so. 4491 is supported by your own statement at page 10 that in 1991.
Where, which portion are you reading?
I'm reading the affidavit filed by the
Paragraph.
paragraph 2.
Paragraph 2. Paragraph 2. Petitioner was pursuant to the order
Has organized the teacher.
and the following, I beg to file this report. Consider Sanjay Guho was appointed by the accord documents. The petitioner was joined in the undertaking on the school was recognized by the secretary 1993. But then
And once he has admitted that he has seen the daylight report, I have no access to that, my lord.
That report was placed at the time of approval of his appointment. My lord is absolutely right. After 8 years at the verge of retirement, he has challenged his memorandum of approval. That point I have taken in report page 4, subpara 2, Roman 2.
আচ্ছা লিখুন তো কি বললাম stuff. The report mentions that the petitioner was appointed by the secretary of the school as organizing teacher. He joined in the unrecognized school on 4th April 1991 and the school was recognized with effect from 1st May 1993. The report of the DI also mentions that the report of the DI denies the averment made by the petitioner in the supplementary affidavit that his name was recorded in the DLIT report. As working since 1991. Stop. Stress has been laid to the fact that the school was accorded recognition only in the year 1993. Stop paragraph. Upon hearing, learned advocate for the petitioner relies on the judgment delivered by the court in the matter of Goshto Bihari Guchait, Banan Dekhben, State of West Bengal and others, reported in 2018 to WBLR Cal 131.
I have not gone through the chart.
Wherein the court was pleased to direct the respondents to condone the deficiency of 1 year and 2 months. Acha. The order impugned in the instant writ petition clearly mentions that on verification of all documents and representations. Verifying that on verifying on verifying all documents and the representations, it is observed that there was sanctioned vacant post of assistant teacher in this school. Stop. President, managing committee and the headmaster said that Sanjay Kumar Guho is working as an organizing teacher from 1991 and recorded by the DLIT team. Quotes closed. Stop paragraph. The report filed by the DI denies that the petitioner was serving since 1991. Stop. There is no denial that the petitioner was working on the date of recognition of this school. Stop.
Paragraph number 4, subparagraph Roman 4.
What you mentioned?
My lord, supplementary affidavit has no basis and no DLIT report has shown by the petitioner showing his upon page 4. Appointment as organized teacher since 1993. Thus, the prayer of the supplementary.
Is there anything to show that he was not working on the day of recognition? That you have not shown anything. Stop.
Only, my lord, I asked the school authority.
DLIT, the District Inspector of Schools in the impugned order clearly records that all documents were verified and it was also noticed that there was vacancy in the sanctioned post of assistant teacher. Stop. The approval of the petitioner was with effect from 26th of October 2016. Stop. The petitioner accepted such approval and did not challenge the date from which the same was the approval was accorded. Stop. In the year 2024, comma, 2 years prior to his normal date of superannuation, comma, the instant writ petition has been filed challenging the said approval letter. Stop paragraph. There is no explanation provided in the writ petition with regard to the delay in approaching the court, challenging the impugned order of the District Inspector of Schools. Stop. Learned advocate representing the petitioner submits that the grievance of the petitioner will be met if the shortfall in his pensionable service period is condoned. Stop paragraph. The six months in the pensionable service period is condonable as per the service rule of the petitioner. Stop. The petitioner has a shortfall of approximately 8 months. And how many days?
4 days হবে তাই তো 60 26 10 60 হয়ে যায়
Acha. 8 months. Stop. Next. As it appears that now in Goshto Bihari Guchait, comma, The court held that the grant of pensionary relief to the retired person was introduced by the government as a social beneficial scheme. And the respondents cannot deny to condone the deficiency in qualifying service period through grant of notional approval only for the purpose of disbursement of pensionary benefit. Sorry. Provided the petitioner's name features in the
Kindly do not include that school is not cooperating. They have seen it, DI has approved that, I have seen it, I have verified it. If that
DLIT.
is there, it will not be allowed.
Stop. In the instant case, it appears that though the district inspector of schools found that the school was though the district inspector of schools recorded that there was sanctioned vacant post on recognition of the school in the year 1993, but proceeded to accord approval of appointment with effect from a later date. Stop. No reason has been mentioned as to why the service of the petitioner was approved not from the day the school stood recognized. Stop. As the petitioner, now as at the time of hearing, the president of the managing committee and the headmaster of the school disclosed that the petitioner was serving as organizer teacher and the school stood recognized from 1993, the court is inclined to direct the
Secretary, School Education Department is authority to condone the deficiency of service in pension.
Secretary of the School Education Department.
Yes, ma'am.
To condone the deficiency in shortfall of service of the petitioner only for the purpose of for disbursement of pensionary benefit in his favor. Stop. it is made absolutely clear that the petitioner does not press for any other prayer but for condoning the shortfall of the qualifying service period for receiving pension. Stop. The notional approval for entitling the petitioner to receive the pension will not permit the petitioner to claim for salary for any period that he did not work. Stop. The deficiency in the shortfall of the service period will only be condoned. Stop. The aforesaid respondent shall approve the grant of notional benefit and ensure that the pensionary benefit in favor of the petitioner may be calculated and disbursed. Stop. The writ petition stands disposed of.
Grateful to you. Madam, kindly,
Grateful, madam.
Withdraw the blame on me that I have said so. Lordship say the belated moving, therefore not this portion cannot be at all.
I have deliberately recorded your concession because this matter is going to be carried in appeal and then further orders are to be sought for. Today you are here, tomorrow somebody else will be there.
I should not, my client should not blame me that.
But then it is you who made the submission. You are taking the responsibility.
Not admissible at all. This is not admissible after such a long period.
In that case, I dismiss the writ petition because there is nothing.
Leave it, leave it. I undertake to do this. I comply with that. I said persuade my client, they accept. No problem.
Because you do not have any document to show.
I have only admission on the part of the DA.
This is, the
Thank you,
admission remains unchallenged.
I am grateful to you.
Application disposed. Acha, affidavit by the DI and the exception thereto by the petitioner filed in court be retained with the records.
Grateful, madam.